Yes,
My Lord.
yes.
My Lord, I beg to mention one unlisted matter, that is criminal petition.
What is the urgency?
My Lord, one FIR is lodged against me.
No, what is the urgency?
My
that
Lord,
you have to today?
final argument is fixed on 27th of this month. So I have challenged the juvenility, but that has not been heard. My application has been rejected. The witness was not examined.
You
Obligation.
filed it. Filed it. You
File,
filed-
I have filed one.
I'd like to mention item number 5. On behalf of Peter Park, this matter may be fixed on 27 February.
27, we have a lot of matters. Not on 27. On the prayer of Mr. T. Tapak. Prayed on the prayer made on behalf of Mr. T. Tapak. List this matters again on 11/3/2024.
May I, Your Lordship?
Yes.
I beg to mention item number 34 on behalf of Mr. Elbam for the petitioner. Your Lordship, this matter may kindly be placed after 3 weeks.
On the prayer made on behalf of Mr. Elbam, learned counsel for the petitioner, learned counsel for the appellant. This matters again after 2 weeks on a date to be fixed by the registrar.
Obliged.
Your Lordship, I would like to mention item number 11, Your Lordship. Item number 11. The conducting counsel, due to some health issues, could not be present today. So the matter may be fixed for 1st of March.
1st of March, it will go beyond that.
Or 29th Feb will also be on.
We'll have it on 4th, 6th.
6th of March.
This matter, 4th. It's a BA, na? 4th. On the prayer of Mr.
G. Talo.
G. Talo, made on behalf of Mr. T. Talo, list this matters again on 6/3.
Yeah, oblige,
Oh,
Your Lordship.
4/3, sorry, 4/3. 4/3.
So your
4/3,
oblige, Your Lordship.
right?
May
Yes,
I,
madam.
Lordship? I would like to mention item number 14. The main counsel of the petitioner is having some medical emergency, so he's out of station. So this matter may be fixed on 4th of March.
On the prayer made on behalf of Mr. H. Burwa, learned counsel appearing for the applicant, list this matter again on 4/3/2024.
Also, I would like to mention item number 15.
Why?
The main counsel is from Guwahati, so he is out of station. So this matter may be also fixed for 4th of March.
Same order. On behalf of Mr. T. Das. Yes.
Obliging.
This is bail matter, my lord.
I know.
The allegation in this case,
The witnesses have not yet been examined here.
yes, my lord.
Then,
My lord, in a similarly.
see, you have been implicated by all, and you being in a position, and that was the reason why the last time you were not granted the bail.
The reason
And
was,
the incident here is you along with the college school authorities,
author, principal.
all.
My lord, principal has been granted.
I'm not very sanguine here.
Principal has been granted bail.
That is on a different footing altogether. He is at least, he'll be at that he has not informed. You are the perpetrator.
My lord,
And see, in your statement also you have said that the school authorities knew you and the next year they were about to terminate your services. Then this person does not deserve. Let him be there. Because there is a chance of you influencing. Yes, ma'am.
Lordship, also Lordship, there is two Lordship victims. This notice may be served to the victims Lordship. They have made party 2 and 3 Lordship.
We'll not. We'll not. We'll dismiss this.
Lordship.
my lord,
Let me submit my lord.
You want some time? No problem.
My lord, in this case, the allegation is of molestation.
Be that as it
In
may.
the previous, in the court below, my lord,
The manner in which it was being done and the power you exercise, we are not convinced
My
that
lord,
you will not influence
my
them.
lord, in a court below, the ground of rejection of bail was there. I am residing in a hostel.
No, no, that we are not concerned.
My lord,
Wherever you
the
reside,
ground I'm saying, my lord.
I know,
the
I
ground-
have seen it.
Ah.
Because you are in a residential school, so you will be able to influence, but
Yes, yes.
we are not concerned with that.
But now, my lord, the students, two students who are the informant here,
They have moved
they
out.
have moved there.
Moved
They have
out.
taken
That you
their
have said.
school certificate, school living certificate, my lord. They are no longer in the hostel, my lord. So there is no chance of influencing the witnesses, my lord.
I'm not very sanguine, Mr. Concept. I've made myself clear.
My lord,
How many days he is behind bars?
6 months. Actually, in this kind of matter, trial should conclude within 6 months.
Hmm.
But now, my lord, the presiding official is on medical leave, for long leave, my lord. There are no chance of.
So it is not, it's not somebody's scheme, but it is misfortune that the person fell ill. That is why the trial is not taking place.
As per this record, the speedy trial is going on, Lordship. Then within 1 year, this
So if
trial will be
it's
closed.
not keeping well, that's the reason.
My lord, there is no reason for keeping me in the custody, my lord.
No, the custody is the only fear is how you will, after coming out, how you will be.
No, there is no chance of influence, my lord, and no chance of tampering the evidence, my lord.
On hearing the learned counsel for the parties, list this matter again on 29 to 2024. We'll think
29,
2.
29, my lord, I will be absent.
When do you want it?
Just after till 12, I will be absent. But
Okay.
14, my lord.
14.
14, if it is not holiday.
14 is not a holiday.
Online.
Madam, you also see better.
Alright.
There you
Yes.
go. Your Lordship. I filed this bail application number 13/24 under section 439 for enlargement of the accused person. Srimati Gaidi Musa.
You're not the,
I'm the applicant.
no, the accused is not the main accused.
Yes, sir.
Come to your paragraph 6.
Yes, yes, not many.
That is just the tip of the iceberg, what you have said,
Yes, sir.
right? Let her be behind for some more time. We'll reject it or, madam,
Lordship.
we'll reject it or
No,
you
at
want us to
least-
call the city?
Mr. LCR, Lordship.
Sure. But any progress made in the, nothing? I think the charge sheet,
If charge is submitted, then we have called LCR, Lordship.
no, I know that, but any
Okay.
progress made in the trial? Has the trial begun?
No, Your Lord.
Huh?
No, Your Lord.
Then what more material will come? Charge sheet was filed on? Charge sheet filed? Charge sheet has not been filed actually.
No, Lordship, we don't have whisper of filing charge. It's only Lordship, the PS case, Lordship.
You have your case diary?
Yes, Lordship.
Heard Mr. So-and-so, also heard Mr. So-and-so, learned additional PP appearing for the state respondents. List this matter again on how long will it take, ma'am? Chimpu.
29, Lordship, 29 February.
29 to 2024. Learned PP shall, additional PP shall on that day produce the updated case diary.
Scan copy of the case diary.
Huh?
Scan copy of the case
Scanned
diary.
copy of the case diary pertaining to Chimpu Police Station, case number 85/23, registered under section 20, bracketed small b, bracketed small to page 2, mark here. B 27A 29 of NDPS Act, page 2, tick correct. Huh?
Right.
Yes, Council.
Yes.
You are asking for
Yeah.
washing.
This is,
Why should we exercise our powers here? It's a, you have a relief, you have a way under 320, go there.
Yes. Actually,
Or you show me a law that this court, under this circumstances, also should exercise 482.
my lord, exactly, the CDM, the CDM court, it takes a long time.
That's no answer.
So,
That cannot be a reason to invoke the powers of this court, Mr. Consul. Will not. Because when you have a procedure prescribed under 320, you see,
no,
clear cut
correct,
procedure
correct.
is there. And why should we here?
but then,
If there was a non-compoundable provision here, I would have come in. And I have come in also.
my lord, here, actually.
Or you show me a law that under this thing, 482, this court can act.
This court have, sovereign power to pass.
We have powers, 482 gives us that power, but that power is not to be exercised in matters like this,
My lord.
wherein you have a remedy by filing an application for compounding the offenses.
And these things, my lord, we have already experienced. We have already, like the same similar case.
Or you
that-
show me, Mr. Counsel, you show me a law of this High Court or the Supreme Court that a purely compoundable case, this court can come in.
My lord, maybe I'll bring the law and next.
Please.
Maybe this matter will be taken up next year.
Whenever you want it.
And maybe call the record of the.
No.
From the PS.
No. No, there is no use. No need.
My lord,
Even if I allow this, the records are not required because your
Yes.
materials
My
are.
lord, here, both the parties are ready.
Parties are
That
ready,
will-
but this court is not ready to exercise its 482 when you have the power, when the matter can be
That's why-
compoundable.
That's why I mean.
Or you show me a law.
My lord, I'm coming that. We have already, say similar nature of case, we have already tried before the honorable CGM, but here, no. after-
Once you-
After she see, we can consider, but now, that's why this parties, they are busy in the somewhere, they.
Their convenience cannot be the reason for me to exercise my powers under 482. You show me a law, I'll come in your
Yes,
favor. I'm open.
next time.
When you want it. When you want it.
We can.
2 weeks. On the prayer made on behalf of the Learned Council for the petitioner. List this matters again after 2 weeks to facilitate the Learned Council to place on record case laws which requires this court to exercise its jurisdiction under section 482 of the Code of Criminal Procedure 1973 to quash FIR registered under sections which are all compoundable. This after 2 weeks on a date to be fixed by the registry.
May I, Lordship? Lordship, this is a joint petition filed by petitioner number 1 and 2 who are wife and husband under section 482 for quashing of FIR of eternal woman PS case number, which has been registered as 498A plus 323. So it is non-compoundable.
Yes, madam, what do you say?
Lordship, if this is matrimonial issue, then Lordship, if compromise, Lordship, there can be very.
FIR is in page 15, type. Okay.
It is that funeral one, na?
Yes, Lordship,
After drinking in that funeral.
yes, Lordship.
Otherwise, we'll stay the proceeding and call for the scan copy of the LCR.
Not necessarily, Lordship, we have annexed the last order also.
If you have any objection here, any doubt, tell me. Otherwise, I'll question.
Lordship, usually Lordship in the motion state, Lordship will stay the proceeding and call for the scan copy of the LCR so that we'll see the whatever the on the next date what situation trial is going on, Lordship.
Trial is started.
No, Lordship, I have annexed the last order. It says like next is for framing of charges. Dear the Lordship, I have annexed the all entire
Okay,
documents.
madam is having an objection. We'll have it after a week. We'll caution.
Yes, Lordship.
Today,
Stay proceeding, Lordship, no issue,
oh,
Lordship.
no problem. That too, I'll have to, I will. Anyway, she has a thing, let her have it. Heard Mr. So-and-so, running counsel for the petition, also heard Mr. So-and-so. List this matter again on. We are not calling for the CD. We are
No,
not
but-
calling for the LCR because charge has not been framed yet. What material would be there? Charge sheet is here on record. Charge sheet is before us, right? Only to allow you to make your submissions, I'm giving 1 day. Okay, list so-and-so, heard so-and-so. List this matter again on 29
Yes.
to 2024 to enable the learned APP to make a submissions in the matter. Only for you, I'm deferring the.
Lordship, yes,
In the
Lordship, the
meanwhile-
order, Lordship, the page 37, Lordship, they have already, Lordship, the case fixed for CC, Lordship.
Huh?
That, this case has fixed for CC, Lordship.
But so the charge framing only, copies only.
Lordship, this way, Lordship, scan copy of the LC.
What will I get? It's already before me.
Lordship.
If you dispute this, yes, I'll get it.
No, Lordship, actually, this last date was on 5th one, Lordship.
Ah.
After that, we have.
After
no
that,
date.
next date is 6/3.
60, yes.
So then nothing is happening. I'm giving it if you find anything.
Otherwise,
tell me.
Lordship, no issue, Lordship, because this, matrimonial issue, Lordship, they have already settled it.
Settled it. Okay, 29th we'll dispose it. Or do you want me to dispose it of today? Or 29?
Today also, I am settled
You're not
on
right.
the same.
लिखो हट Mr. So and so खाली नाम तो लिख के रखना and also so and so you will have the orders by
Yes.
Monday. Dispose of.
Duly ordered.
Item number 6.
My Lordship.
Mr. Counsel,
Yeah, Lordship.
come to page 23. Quashing.
Yes, Lordship.
Come to page 23.
Yeah, Lordship.
Huh?
FIR.
Now read the opening lines of that. It's in the banner, it's in the pad of an organization, right?
Yes, United
Fine, whatever it is.
Indigenous People.
Now you read the opening lines. We do respect we.
We UAIFL.
So it is not individuals, it's an organization.
Yes.
Now come to your compromise date. Where is that organization here?
Lordship, this organization is no more exist.
Then-
Exist. And this both were the complainant, principal
Cannot be, you go there,
complainant.
that
Yes.
cannot be a ground. When an organization has registered an FIR, how can two individuals
Lordship,
in their own capacity withdraw it? They have not said that they are doing it on behalf of that organization. The organization is not there, you'll have to go there.
Lordship, in my pleading also, I have stated that.
Where?
Since
No, we can't permit this. They'll go and make your statements in before the trial court. And if the allegation is that he had instigated, then though it would be a serious offense.
Lordship,
Para?
para 3,
Para?
para 3, page number 5.
My lordship.
That is the statement which of the fact,
Lordship, yeah.
but does not say that you have done it in your individual capacity. It
Lordship,
was done as the organization.
Yes.
And the wording is we organization, not we petition number 2 and 3.
Lordship, moreover, the cases of 2019, now in present day, this organization is no more active.
Yes, madam.
Lordship. Yeah, Lordship, in the last order, Lordship,
Hmm.
the accused was absent, Lordship.
Hmm.
And the reweeks on 11/3/23, Lordship, 24.
No, if you have to
Yes,
make a compromise, we will not. You go, make your statements there.
Lordship.
He'll be freed.
Lordship, since the section invoked is our non-compoundable
Fine.
section. This court
You,
has an
no,
inherent power.
if you are the witnesses there. The petition number 2 and 3 are the witnesses.
Lordship.
They'll make their statement. Then that will be.
Yes, that is their lordship, but this court has inherent power. to
Fine,
invoke the
but
section
we will
480,
have
yes.
to be sure. But with this agreement, how can we? You satisfy me on that. Because this agreement is an individual. 3 individuals have come in. But that FIR is by an organization.
The FIR was filed by this
No.
2 individuals.
UAPI. See the opening line.
Yes, lordship, that.
When-
gone through.
That's the only thing I am having.
While representing this organization, also these 2 has come
Fine.
into the compromise.
Organization cannot be individuals. Organization is organization. If there was a resolution, something empowering, I would have understood.
In fact,
It's technical,
to be
but
very fair, lordship, this organization is no more exists in present day.
fine, nobody will go and depose evidence. He'll be otherwise also acquitted. Think over the matter.
Otherwise, lordship may kindly allow me to withdraw this petition and
No, don't. Court, I have the right to ask you something. That asking does not mean that you don't have a case.
lordship.
I just want you to come out. Give me that material. Please don't have this habit of immediately withdrawing cases.
Lordship.
That's not fair to your clients. Huh? You work on it, satisfy me, I'll pass orders.
Lordship.
But I'll ask questions. Whatever I read, whatever I doubt comes, I'll immediately ask.
Yes, lordship.
But for that, don't start withdrawing petitions. That's not the practice, right?
Lordship.
And you can't withdraw a petition without your instruction of your clients. This is not your petition.
Lordship. That is it.
So next time, don't do that. When do you want it?
I need that, lordship.
When do you tell me?
27th of this.
27th. 27, we have some cases. Let us put it on 6th. You have time till 11th,
27th.
6th, right? You are here? On the prayer made prayer made on behalf by the petitioner, by the counsel for the petitioner. List this matter again on 6/3/2024. You see, if there is, you can satisfy me that under such circumstances, that deed agreement made by those 2 persons will also hold the field.
Sure. I will satisfy.
That much only. And for that, try to look into the charge sheet. Whether they are the only 2 witnesses, how, develop your argument in that.
Lordship.
Then come back.
Deep
Then
note.
I'll pass on this.
Watch out.
Yes, what is this happening? If this is true, then you're violating your own.
Correct, my lord. But before coming into the merit of the case, my lord, the locus of the petitioner has to be taken into care first, my lord.
No, he has made a statement here that he is also qualified under that.
But who is representing before your lordship, my lord? It is the farm owner or somebody else, my lord.
LY Enterprises represented by board.
And there is no any power of attorney, my lord, they have annexed.
I think there is one way. Who is this Bordenini?
Well, he is a representative. Let me-
I am a representative of that, I have been authorized by.
Where is that authorization? Have you made a statement? He has a point there. Okay, para 2, he has made a statement.
The statement is all right, my lord. Where is the substantive document for that, my lord?
That we can ask him. You
My
have a
lord.
document to that effect? Where?
My lord, I have authorized.
No, where is that authorization?
Yeah.
Show, Mr. It's not annexed
Well,
here.
My lord,
Not annexed, but
we have already submitted before the.
Where?
conference.
it's not annexed.
Next,
Where? Page?
my lord.
It's only that annexure 1 is that enlistment order.
Yes.
Yes, my lord.
Annexure 2 is the NIT, my lord. Manual NIT. Then the annexure 3 is the government order, the section order. Same, my lord, type copy annexure 4, my lord, it's a government instruction against so and so. 5 government.
No, it's
instruction.
not there, it's not there.
not
I've
there.
checked it, it's not there. Oh yeah, it's there, page 34. It's there.
No, page 32 and
34,
31.
34,
34, my lord.
34, last page.
Well, I don't have 34, my lord. My ends 33, my lord. That is the
Okay,
problem.
that's It's okay, fine. Yeah, the same one he has annexed. So,
My lord, generally, my lord, this is not the authorization letter, only this one is registered properly, my lord.
fine.
Anyway, my lord, these are too technical.
Technicality will not go when the issue is very serious. Now tell me, what do you propose?
Now, for that, my lord, we have to see the area wise, whether, my lord, that.
It's more than 1 crores,
yes,
each
yes.
of the wood.
Yes, yes.
So as per your official
About-
instructions,
It says, my lord,
orders, it says 50 lakhs and above,
e-tendering.
then you rely on the CPWD.
CPWD.
CPWD is same, and you have an act also.
Yes, district
Which
based.
is very specific to this state.
Yes, yes. Now we have to see, my lord, geographically and the telecommunication facility, whether, my lord, e-tender is possible or not in that area, my lord. And what made them to, my lord,
No.
come into but manually, my lord,
If
that
the e-tendering is not possible from that office,
can be done here also, exactly, lordship. But that, let me take the instruction or compel them to go for manual,
but
my
don't
lord.
proceed with the work.
Yes,
Mr. So-and-so, learned additional advocate general submits that he be granted 10 days time,
10 days, my lord.
10 days time to receive instructions in the matter. Full stop. Accordingly, list this matter again on, when do you want it to show? Now,
10 days.
give me a date convenient to you, sir.
Can it be on 11, my lord?
11.
11 March.
List again on 11/3/2024. Full stop. Till the next returnable date, the respondents are directed not to finalize and or award the contract in pursuance to the notice inviting bid number, page 13, underline portion. Full.
My lord, not all the packages, if I believe in. All packages.
All packages,
all
should-
packages.
all packages,
All
because they,
packages above
everything
the
will
1
have,
crore, my lord.
all
the
are 1 crore.
packages.
One is 1 crore, one is
Yes,
4
ma'am.
crore, one is something. We'll have it, we'll see
My lord,
on
yes.
11th. Right.
No, my lord.
My lord,
Yes, you are paying for the department.
yes, man, I'm appearing for this education department. as
Now,
explaining-
why this time the reservation for PWD, that's
Yes,
your
yes,
case, it
my
was
lord.
not made?
My lord, that I have to take instruction, my lord. The-
Because in your earlier processes, I have seen 4% was.
My lord,
duly
my lord, my lord, there must be some communication gap, my lord, I'll just.
You do it within that seniority only.
My lord, my lord,
But if they come within that
Yes,
seniority,
yes, my lord.
then
That
from
is sure,
there
my
they
lord.
will get 4%.
that is my lord, I agree, my lord.
So you undertake that you will not proceed with this, we'll give you a deal. I'll not pass an order,
My lord,
because if I pass an order, the whole thing may get stalled.
my lord, my
Or
lord,
you want me to pass an order, I'll pass an order.
my lord, my lord,
We'll have it next week,
my lord,
hmm?
my lord.
Right?
My lord,
When is the meeting held? Next meeting date has not been given. Departmental DRC meeting,
Yes,
date has been given.
it was already convened on 16th,
16th.
16th February. Now
Okay.
the result is not, the result has
Okay,
not been
okay, okay,
made public.
okay. Heard Mr. So-and-so, learned counsel for the petitioner, also heard Mr. So-and-so. You are appearing for?
My lord, I'm appearing for respondent number, all my lord, 1, 2, 4, my lord.
Wonderful.
Standing
Appearing
counsel
for
education.
Standing Council Education Department.
Yes, my lord.
For the respondent, for all the respondents. Full stop. Mr. So-and-so, learned Standing Council Education Department, prays that he be granted 2 weeks' time
My lord.
to bring on record the necessary instruction as to why, to receive instructions as to why the 4% quota for persons with benchmark disability was not provided for in the process as involved in the present proceedings. Full stop. List this matter again after on today is 23. On 11/3/2024. It is directed that till the next returnable date, the authorities may process with the preparation of the select list in pursuance to the memorandum dated 5/2/2024. Right? That's the memorandum.
Yes.
Dated 5/2/2024, and also the recommendations of the DRC, which is stated to have been held on 16/2/2024. However, the final select list in the matter shall not be published without leave of this court.
My lord, the document, the petition that have furnished with me, my lord, it's not legible.
No, the petitioner is directed to furnish 2 copies of the eligible copies of the writ petition, furnish a legible copy of the writ petition to the Learned Standing Council within the course of the day. During the course of the day. Just get that instruction. We will.
Item number 9.
Yes.
My lord, I'm on behalf of the respondent.
Okay.
So before this case goes for admission, they have to comply with one provision of CPC, my lord, which has not been complied.
Yes, that payment.
Yes, ma'am.
Yes.
Lordship,
Hmm.
Lordship, here, my respectful submission would be the payment of security amount is not mandatory only when.
Sorry. See
When I-
your written statement.
When I am trying for a stay of the execution,
No.
in that circumstances, Lordship.
This is a debt. This is not security. If you look into maybe you had collected this money from your staff, they had taken loans from him, be that as it may. But now the matter has gone beyond that security stage. It is a liability on you. Until and unless we don't interfere with this, that liability is yours. 14 lakhs, that issue number 1 decided in your favor.
Yes.
But considering your written statements made therein that you have repaid 5 lakhs and you will repay the balance.
Yes.
What more is there? Read, come back. He has a point. I'll not take you by surprise. Read, come back.
Yes.
If we can also go through it, you also go. Mr. Counsel, next day. How much is that? 25%.
My lord, exact percentage is not mentioned, ma'am.
But he'll have to make
Yes,
that
he has
deposit.
to deposit the amount.
Before the first step, this is the first appeal, yes.
Yes.
Before the first appeal, you have to. On a prayer made on behalf of Mr. So-and-so Learned Counsel appearing for the appellant, this matter again when?
After 2 weeks.
after 2 weeks, on a date 2 weeks by the registrar. Just reiterate your submissions on it.
Matter number 10.
May it please, Your Lordship. Your Lordship, item number 10 and 12 may be passed over for timing, Your Honor. Your Lordship, the petitioner, counsel for the petitioner is stuck in the traffic.
Okay, okay, today is, it's a big traffic.
That's all.
After some time, madam.
10 and 12,
After 10 and 12, after this.
highly obliged.
May I please, Your Honor?
Hmm.
The conducting council is on, it's stuck in the traffic, Your Honor.
Okay, after some time.
Yes. Much obliged.
Matter number 16.
15.
Yes. You are for the respondents.
Yes, my,
Who is for the petition?
through, it was, in a cost list through RVC, must be through video conference.
Are you ready with the matter?
My lord. They are here with the 482 for passing of the FIR. I have very small submission to be made. Yes. This is still at investigating stage, premature for 482,
But what I find is
my lord.
that it's a pure civil dispute.
It appears to be, my lord, but we, my lord, there, the signature, the resignation letter of the respondent, there is where our contention, it has been forged. The email has been sent to the register of companies seeking resignation on that, on the
That
day.
you have stated.
Yes, on
That
the
you have
day
stated.
when his daughter
And
was
he-
to be appointed as one of the board in
And
the.
he
board.
has also send you some mails.
Yes,
That's what your
my
case
lord.
is.
The veracity of the email is questionable. Why should a father,
To that aspect, we'll respond. I am led by.
Is it item 16, Millard?
Yes, yes, sir, you can proceed.
Oh, I'm sorry. I am appearing for the petitioner
Huh.
and if I can place the case, Millard, of mine. It's a 482 petition for questioning and the prayers are on page 31 of the petition, your lordships will see. What has happened is there is a FIR, 3 years back it was lodged on 25th February 2021. And it arises under the section 418, 423, read with 120B Millard of the substantive IPC. And then there is what we are more concerned is 31P of SC/ST Act. Now, as your lordship knows well, 418 and 423 are non-cognizable and bailable and triable by any magistrate. So no one is much concerned, Millard, on those sections of the IPC. The core question is whether even a prima facie case is made out under 31P, because it is purely a commercial dispute. And I will read only one document, Millard, for you, that is the complaint itself. At least in 12 places, they themselves are saying it is a business dispute. Now, if it is a business dispute, your lordship knows very well, business dispute and non-cognizable, bailable, triable by any court, then Bhajanlal, that 1022 and 10207 of the guideline of Bhajanlal applies, Millard. This is the threshold submission.
You can come to the second paragraph of page 48. That is the only place wherein that they allege SC/ST atrocities.
Yes, Millard, that is the only thing I am obliged, and if your lordship will permit me, I would like to place that very first FIR from page 45 to 49. And as I said, Millard, they themselves are at least in 10 places are saying that it is a business dispute. It is about the control of a company which is established as back as in 1979 by V. Millard. The two alleged accused were before you in 482 petition. If you kindly permit me, Millard, and come to page 45, the very first page of that FIR, Millard, 25th February 2021. May I proceed?
It's fine. I've gone through it, Mr.
Yes,
Counsel,
yes.
Srinagar, I've gone through it. You can have, because this issue comes up only in page 48. If there is this issue somewhere else, you can just point that out.
No, your lordship is just appropriately knocking exactly on the same para, because but for that one sentence, commit crime under SC/ST Act, is they are engaging defamation campaign against me and trying to influence numerous government agencies in order to put me out of business. Now, this is the only reference of SC/ST Act, because otherwise, if it is business dispute and non-cognizable offenses, there's nothing in the proceedings, Millard. And kindly see, but for that, as I said, I will just, if you don't mind, in half a
Fine,
minute,
please.
half a minute, I will only show where the word business is appearing in this 5 pages FIR. If you kindly come on very first page, page 45, the last line, 3 line, Rajendra Kumar Lahoti has launched a sinister campaign to oust me from my business, properties and company by involving all sorts of illegal and nefarious tactics, including extortion, mental torture, threat, etc., etc. Kindly come to the next page. What is the first concern of there? And there is a preliminary, what might be called the status report in my favor also, which I will draw your attention a little later. On page 46, the first para is important. Today, 2 unidentified miscreants aged about so-and-so came to me on bike when I was walking outside my house and threatened me of dire consequences in the Hindi language that I should move back to Delhi immediately and hand over the Chogam mill. Again, the concern is this ownership or the proprietorship of this mill back to Lahoti, or else they would shoot me and kill me. The exact words used by them in Hindi were, "Wapas Delhi jao or veneer mill Lahoti saab ko wapas kar do, nahi to agli baar goli maar denge." This is one of the incident which is referred, and your lordship will see in the preliminary investigation report, what is status report, what is this about. Now in paragraph, the second paragraph, the only reference is the 4th line. I came to know that Rajendra Kumar Lahoti, along with his son, were usurping money to the tune of crores of rupees per year from my sawmill and veneer mill. I of course don't understand how one can say my sawmill when it is a company. This was a clear crime of cheating and criminal breach of trust. Yes, if it is at all under the penal code, your lordship knows. When I confronted the aforesaid Rajendra Kumar and Anand Lahoti about this matter, they resolved to not reply to my message on WhatsApp and quite alarmingly stole the pillar machine from the premises of Chogam sawmill. He committed this act when he was reminded by me that he is exploiting my father's good nature for the last many years, and that he ought to give us proper share, considering the fact that we are majority shareholder in the company, as well as the fact that my father owns license number so and so. Again, the business rivalry. And on the next page, the first para, the last sentence, ensuring that the aforesaid veneer and sawmill ceases to function, thereby putting financial pressure on us by closing down our business. That one of the modus operandi being engaged by Rajendra Kumar and Anand Lahoti is that they are bribing members of the GST department. This is the second allegation. Are higher up and are regularly trying up to raid my premises as well as the trucks and carry the goods manufactured by the veneer mills. I'm not controlling the GST department. If GST department had Millard kindly appreciate, have some information and they want to initiate some action, it is on them. The entire aim of Rajendra and Anand Lahoti is to drive me out of business. Again, the business Millard, by harassing and repeatedly by using tax officer to visit my premises. And then Millard, the next para, the aim is to care and threaten me and discourage a single woman such as me entering the place of business as the same is being regularly raided without any cause of personal from the GST. Since I have been controlling this business and for less than 2 months, even a lay persons can make out that the question of GST evasion simply doesn't even arise. It also pertinent to mention here that Rajendra Kumar Lahoti and Anand Lahoti are also blocking me and taking over the business on the basis of my mother's succession certificate. And Millard, on the next page, the last para, I'm sorry, one sentence before that. I already have a succession certificate from a court of law. It speaks volume about each fact and complaint made by me in a FIR to be true and thereby exposes the real objective of Rajendra Kumar and Anand Lahoti, which is to block my inheritance and to, on other end, extort my business from me as elucidated by me in the complaint. You are also requested to restrain Rajendra Kumar and Anand Lahoti from further breaking the law and commit crimes under the SC/ST Act as they are engaging in a defamation campaign against me and also trying to influence numerous government agencies in order to put me out of business. I have tried to frivolous and vexatious complaint in various forums when actually all they are trying to do is illegally extort me my business. So again, the business is appearing, and in the next para, which is the concluding para of this FIR, again the top of the page, the first para, in the light of aforesaid facts and circumstances, you are requested to take action in accordance with the criminal law and bring the aforementioned criminals in justice whose sole intention is to extort and the entire business of the single tribal lady by coercion and threat, being nefarious means and thereby illegally assert the business. And then again, SC/ST Act second time is used in this para in the last sentence. Now, this is the given background, Millard, and kindly see what is the preliminary investigation status report, which starts on page 96. Under the direction, there was a direction order of 19th August 2021, which your lordship will get and oblige me by referring only one page, page 89. It was by Sessions Judge. On page 89, this is the direction which the learned Sessions Judge has given. On page 89, last para, this court, after hearing both the counsels and having gone through the document along with certain citations submitted by the counsel of the applicant, is of the view that the IO of this present case should be called with the direction to the OC PS Chogam to submit his status report with regard to the FIR dated so and so, said to have been lost by the Nang Sunita Namchum. She is the daughter of the present informant, to find out if the said FIR is identical with the present FIR. There is another FIR by the father said to have been filed by Sri Cho Mew Namchum or not. Accordingly, IO is directed to appear so and so. Let this matter be listed. Now, pursuant to this command or direction, an preliminary status report was filed, which start on page 96, Millard, and your lordship will come straight, because from 96 to 90 up to 100 are the references in the background. Kindly come, Millard, and oblige me by referring page 101. Brief progress of the inquiry is as under. The matter informed by SP Namsai and Eid. I'm sorry. The lordship had that page?
Yes, I have.
101. The matter informed by SP Namsai and he directed to conduct an inquiry. The complaint Nang Sunita Namchun examined. PO visited all the Naka and police point briefed. Plainclothes police personnel deployed along with the residences area. Alleged accused Rajendra Kumar Lahoti and Anand Lahoti summoned. I visited, kindly mark summoned, and they appeared thereafter. I visited the house of Nang Sunita and directed submit the Chogam Sawmill Private Limited related document. During the course of inquiry, the complainant Sunita Namchum informed that a factory was run by Rajendra Kumar Lahoti and Anand Lahoti. They could not clear her due payment, which is approximately so and so, and presently self-running the factory. Also informed all the documents were illegally stolen by Rajendra Kumar Lahoti and Anand Lahoti. And also I tried to meet her father Cho Mew Namchum, Then she stated that he is old and his physical health condition not good. Regarding the bikes, all the entry and exit point were sealed due to COVID-19 lockdown and deployed the police personnel 24/7 it would be, and no movement notice any bikes. And kindly remember the first allegation that 2 persons came on the bike and threatened and make those Hindi remarks. Rajendra Kumar Lahoti and Anand Lahoti were submitted a written replies to the PS, which also is here, that the company was formed. Kindly mark this part. 1979, the company was formed. If your lordship is with me,
Yes,
102, the middle. 79, the company was formed, Chogam So and Veneer Mill Private Limited, as per company law and memorandum association, and all the functions were going smoothly as per the law and guideline given by the government time. During 2020, COVID-19 pandemic, all the activities were halted, and during 2021, Nang Sunita Namchum took over the company function, which is illegal as the document C is not competent stakeholder. All the documents were enclosed. Also, a complaint filed by Anand Lahoti against is also enclosed. Kindly mark all the documents which the investigating officer wanted were given by these two guys, Millard. After meeting Nang Sumita Namchum and inquired about the complaint and rather health condition, she again stated that the physical health condition not good and he is in isolation. I informed her the matter of you both parties should be settled amicably as it is purely a business dispute or file appropriate authority. And kindly skip the next parameter. It has no relevance directly to this case. During the preliminary inquiry, it's learned that the company was formed in 79, namely Chogam So and Veneer Mill Private Limited, as per the company law and memorandum of association. And the present director of the company are, now who are the director? This kindly appreciate. Cho Mehum Namchum, Rajendra Kumar Lahoti, and Anand Lahoti, and it's a business dispute over the ownership of the Chogam So and Veneer Mills Private Limited and their power and function with both the parties.
What is the stage of the proceedings now? Yes, this case? There is a stay order here.
Yes.
Yes, my lord.
Is it
No coercive measures should be taken. That
I
is
My
why.
lord, that
And lordship.
order dated is also, my lord, is violative of the guideline passed by Supreme Court in Niharika infrastructure. Order dated, my lord, 2/6/2022.
Millard, there are two pertinent orders, Millard.
2/6/2022.
First is 29/11/2021, where I came and appeared physically, Millard.
No,
Last
so I'm
para.
just trying to get the orders of this court here.
2/6/2022.
2/6/2022. 29/11/2022.
Yes, 29/11/2021, I argued, Millard, and I.
And case diary was called for.
Yes, Millard. Case diary was called and I had cited all the judgments.
Next order is?
My lord.
Next order is?
Next
Page.
2020.
Okay.
Before that, your lordship would see 18.5.
Well, there is no interim, but no coercive. So the investing authority are of the misunderstanding. When there is no coercive, such orders are passed, they have halted the investigation, and they have not appeared before the IO.
2/6/2022 is the order, Millard. The next
I got
order.
it.
This is
I got it,
violative
sir.
of
I got
the
it.
Apex
And
Court
as
order
I said
passed
again,
in
I physically
Niharika
came-
infrastructure, my lord.
I-
My lord.
Now, Mr. Counsel, one thing.
My lord.
uh, Whatever my senior has said, fine, let it be there. The senior counsel has made. Just tell me one thing. Forget the IPC sections.
My lord.
Show me the material with regard to that atrocities on SCST.
313.
My lord,
Just saying that there is a possibility, what that page 48, second paragraph
I
indicates,
understand that.
indicates is that there is a possibility. That's no offense. It may be a possibility.
My
only.
lord.
Now show me what is the atrocity these two petitioners have done on you to attract a CST Act. Atrocities, prevention of.
My
Show me
lord,
that act.
in on that perspective, my lord, the investigating authority.
I'm not on the investigation. I'm on your. They can't have an investigation in air.
My
There
lord.
has to be some material brought on record by you.
My lord. My lord,
Till the paragraph above that, It's all with regard to business transactions. Right, you may have a case there.
My lord,
He may have committed a fraud on you, no problem.
my lord.
But will that amount to a charge or offense under the SC/ST prevention of? Just give me the act.
That's fair. Okay, sir.
Precisely 1 P.
So I'm taking 2 minutes, just I'll have a clarification from him.
Yes, my lord. I'm there also to assist you, my lord.
Your Lordship, no. Institutes false, malicious or fictitious suit or criminal or other legal proceedings against a member, scheduled caste, scheduled tribe, okay.
Very good.
My lord. My lord, it is for the trial court to deliver. My lord, on a fair submission, my lord, it might not.
Bhajan Lal, 1992.
My lord, the senior counsel has quoted Bhajan Lal. I will also quote. Bhajan Lal also says, on the face of the
No,
FIR,
on the face of the FIR.
whether there was
I'm not on the other charges.
my lord,
I'm only on that, the violation of this act.
my lord,
I'm only on the violation of this act. The violation of this act cannot be inferred. There has to be materials prima facie disclosed. If
Agree.
I'm wrong, correct.
I
me.
agree, my lord.
Correct
Agree.
me.
Agree.
So on a reading of that FIR, if
My
we
lord.
find that yes, there is an atrocity made or an act which will be covered by the provisions of this act has been done, an offense is made out.
Right.
We'll not even touch it,
My lord.
but just indicate.
But on a fair submission, I also find that this particular section of ST/ST Act might not attract. However,
Then-
my lord,
then
the
we will
other
be-
sections, my lord, I am not
Other sections, even the learned counsel for the petitioner, learned senior counsel may also not like to press that.
my lord.
Correct, correct.
My lord, if they join with cooperate with the investigation in the trial court,
But this,
they can
but this part,
my lord.
I'm only on 31P.
then we'll interfere with 31P to that extent only.
My lord, they're challenging the whole of the FIR.
No, that we can,
My lord.
that we can.
But it's premature state, my lord. Investigation part, my lord.
No, only on that 31P.
Then I agree, my lord. My lord may pass appropriate order, but my lord, the crossing of the FIR, I'm objecting.
No, FIR will not be caught.
My lord.
Now, can I do that? Partly. Satisfy me, sir. Can I take away a part of that charge frame?
Your lordship is sitting in the inherent powers of the Code of Criminal Procedure, my lord. Or of course, substantive IPC. Another is the Special Act. And if I cite only 2 judgments of the Supreme Court,
Please do so.
that if your lordship will come, Miller, directly, of course, I am
also
very
because of
heavily
it, I'm just
banking
having
on
a
Bhajan
clarity.
Lal. I am very heavily banking on Bhajan Lal that 10 paragraph 1022 Miller and 1027. If your lordship will kindly peruse Bhajan Lal what it says, and I know you are very well conversant with Bhajan.
I'm not. Mr. Dubey will vouch for me that I'm not. I'm a student only. I'm a student only on when as criminal law is concerned.
And you want me to believe that, Miller?
You will have to.
With all respect. Now, 102 Bhajan Lal.
Just a moment, sir. Let me just have that.
Citation, your lordship is fully.
Have it.
1992 supplementary 1 SCC 335.
Oh, sorry. Supplementary. Have a copy? No.
No, madam, this, I'm okay.
The other judgment we had given the copy. I'm sorry.
No, it's okay. I have it with me. 1992.
1992 supplementary 1 SCC 335. Supplementary 1 335. Now kindly come straight on page 378.
No, Bhajan Lal is not here.
You are the other one.
Yes.
Bhajan Lal with you, no?
No, my lord. My lord, my case is covered by the reason of Niharika is there.
I'm on Bhajan Lal. I think.
Sir, you just give me the paragraph. Paragraph?
Paragraph 102 Miller. And in SCC citation, it is page 378. Now, if I can place that, Millard, as I said, there are 7 criteria this locus classicus judgment of Supreme Court had laid down. And these are ever continued and accepted guidelines by all the courts in the country. So far as the criminal proceedings are concerned, Quav 482, the scope of 482. Now, as I said, I am on 102, which had 7 subparagraphs. I am on paragraph 2, where the allegation in the first information report and other material, if any, accompany the FIR do not disclose a cognizable offense. Now, this is the first criteria which is required. Disclose a cognizable offense, and there is none. Because both the offenses 418 and 423, read with 120B, are non-cognizable and bailable and also triable by any court. It is one of the ordinary offense because the offense punishable is less than 2 or 3 years. Where the allegation in the first information report and the other materials, if any, accompanying the FIR do not disclose a cognizable offense, justifying an investigation by a police officer under 156(1) of the Code of Criminal Procedure, except under an order of a magistrate within a purview of 155(2) of the Code. This is the first test which Bhajanlal had laid down, Millard, in 1022. Now then kindly see 1027, paragraph 7, or rather subparagraph 7, where a criminal proceeding is manifestly attended with mala fide. Where a criminal proceeding is manifestly attended with mala fide, and or where proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and a view to spite him due to private and personal grudge. Now, these 2 contours, Millard, totally covers the facts of this case. This is my first and the foremost submission, because one cannot go out of the 2 criteria which Bhajanlal laid. The second, the subpara 7 is more pertinent, directly applicable, where a criminal proceeding is manifestly attended with mala fide. What else it could be? 79, the company was established by these 2 accused. Because of the COVID or Corona, they were not able to travel to Arunachal Pradesh. And in that period, the daughter, who is neither a director nor had any bearing in the company, takes over physically. It may happen any day, anywhere, Millard. Of course, in a political scenario we have been seeing in certain countries, that the prime minister or president is not there, gone out of the country. Someone captures the power, which your lordship knows very well. Here, exactly the same thing in a business company had happened. COVID, these people who were running the company from 79 could not go to Arunachal. On a lighter side, I traveled twice to Arunachal. And in the second time when I traveled, I said, this is my last opportunity to come here. And then the presiding judge told me, of course, there is a direct flight which will be there soon, because I have to travel from Delhi to Dibrugarh one day, and Dibrugarh by road 4 hours there, all those things.
Now we have a direct flight, sir. You can just come down. It will take you 20 minutes to reach the High Court from the airport.
But I understand that flight reaches around 11 or so. I would have
We will accommodate you. We will accommodate you. But you need not. You can use this. There is no requirement. This is also fine.
Because
this system is also fine.
I have to argue a matter in the Supreme Court after half an hour also. Otherwise, I would have pleased to be there, Millard. And
It's
so,
okay.
so manifestedly, and it is wreaking vengeance.
Vengeance.
Now, what else it is? I don't think I have to bother you by referring any judgment, any citation of the highest court, though they are consistent, concurrent judgment in large number of cases. And only for your kind information, I am placing Millard, and I think my junior there from Guwahati had supplied the what my
Yes, Mr. Dubey has given me.
books. Yes, Mr. Dubey had done that. Kindly, I don't want to refer all the 9 judgments. Kindly see serial number 1, 2, 6, and 7. One is by Justice Suryakant Millard, and only two paras, paragraph 15 and 16.
Let's pick up the volume.
15 minutes. Ordinarily, when dealing with the offences arising out of the special statute, and kindly mark, and this is your lordship wanted to know, Millard, such as SC/ST Act, the court will be extremely circumspect in the approach. SC/ST Act has been specifically enacted to deter acts of indignity, humiliation, and harassment against the members of the scheduled caste and scheduled tribe. The act is also a recognition of depressing reality, and despite undertaking several measures, the scheduled caste, scheduled tribe
I
continues.
think para 16 covers your case.
Yes, very fully. Yes, especially the part primarily private or civil in nature, or where the alleged offense has not been committed on account of the caste of the
Caste.
victim. This is the test, this is the guideline. These are golden words from the highest court by a judge who will be our Chief Justice maybe after another 2 terms. Now, then kindly see the second case also, Hitesh Verma, Justice Hemant Gupta, of course, who retired recently, Millard, paragraph 6, 11, and 14. 6 probably gives the background. And kindly in para 5, your lordship will find that it also is 482 arising from SC/ST Act. And 6 is the learned counsel for the appellant argued. I'm sorry.
It's okay, please continue, sir. You can continue.
The learned counsel, because you had a very fast pace, I need to continue. The learned counsel for the appellant argued that the dispute relating to property are pending before so and so, and the present FIR has been filed on patently false ground by respondent only to harass the appellant and to abuse of the process of law. It is argued that the allegation leveled in FIR and the subsequent report submitted by the police after investigation doesn't disclose any offense under the act. Furthermore, it is argued, I don't want to read further that para, and kindly come to 11 and 14. 11, they refers to the 3110 of the SC/ST Act and 31R of the ST Act, Millard. And then finally, in para 14, this is how the learned bench concludes. The 4th line, I'm sorry, para 13, sorry. Para 13, 4th line. An offense under the act would be made out when a member of vulnerable section of society is subjected to indignities, humiliation, and harassment. The assertion of the title of a land by either of the parties or not due to either of the indignities, humiliation, and harassment. Every citizen has a right to avail the remedies in accordance with law. Therefore, if the appellant or his family member invoke jurisdiction of civil court or that respondent invoke jurisdiction of civil court, then the parties are availing their remedies in accordance with so and so. And scheduled caste they discussed, Millard. Now, then they refer in paragraph 14 the other judgment of what is called Swaran Singh, etc., which is an old judgment, Millard. And then, Millard, the last and final judgment which I would like to place before you is Ghulam Mustafa by Justice Dinesh Maheshwari and Justice Amanullah, Millard. Paragraph 38. Only one paragraph, Millard.
Page
79.
Page
Yes.
para 38. Give me a minute. It's to which?
Page 87.
Page 87. I am obliged. Now, before page para 38, kindly, Millard, permit me to place paragraph 36 also, the earlier page. What is invincible from the extent case law is that this court has been consistent in interfering in such matters where purely civil dispute, more often than not relating to the land or money, are given the color of criminality, only for the purpose of exerting extra judicial pressure on the party concerned, which we reiterate is nothing but abuse of the process of the court. In the present case, there is a huge and quite frankly unexplained delay of over, I need not do the delay part, Millard. And
Come
then
to para 38.
38. This court will indicate that the officers who institute an FIR based on any complaint are duty bound to be vigilant before invoking any provision of a very stringent statute like SC/ST, which imposes serious penal consequences on the concerned accused. The officer has to be satisfied with the provisions. He seeks to invite prima facie apply to the case at hand. We clarify that our remarks in no manner are to dilute the applicability of special stringent statute, but only to remind the police not to mechanically apply the law Dior's reference to the factual position. Now, these Millard, and there is one more judgment. I do not know whether I refer or not. This by Justice M.R. Shah and Krishna Murari, which is Venkateshwaran, and which only two paras, para 2 and 3. 2 gives the background, Millard, the facts.
Page 88, Millard.
Yes, Venkateshwar.
Venkateshwaran. Millard, kindly
Para?
come to para 3, the only para which I would like to. We have heard Mr. Nagamuthu is one of our eminent criminal lawyer practicing in our court, Millard. For the appellant, original accused and the respondent appearing in person. We have also gone through the complaint and considered the allegation in the complaint made against the accused. Having considered the allegation in the complaint and material record, it appears that initiation of criminal proceeding by the respondent against the appellant original accused for the offense under the provision of SC and ST 1989 is nothing but an abuse of the law, and the court and also provision of SC/ST Act. It appears that a private dispute was going on between the parties with respect to the illegal construction. The only difference is the fact that construction and here the ownership or what might be called the share or the control of the company.
Both are visible.
As per the allegation of the complaint, the original complaint had purchased the vacant land and constructed the building. It is alleged that adjacent to his house, the vacant land on the common pathway, the accused have unlawfully encroached upon pathway and started constructing the temple and thereby have put up illegal construction on the water pipeline, sewerage pipeline, and EB cable. In the entire complaint, there are no allegation that the complaint is obstructed and or interfered with the enjoyment of his right on the property deliberately and willfully, knowing the complaint belongs to SC/ST. From the material record, it appears that a civil dispute is converted into criminal dispute. And
I got it. The next page.
And one small thing, Millard. If when I taken your lordship to the first judgment of Justice Suryakant, kindly see how extremely different the case is. If your lordship come on the brief facts there, only 2 paragraphs, Millard. This is something very, very significant. Ramavatar, who are the neighbor and live in adjoining houses, were entangled in property dispute with respect to the portion of the land. So and so broke down a wall. When this was resisted, quarrel ensued between the parties and appellant threw a brick on the complainant. Thereafter, the incident was reported and the complainant was lodged in police station so and so, and MLC was also performed. Since the nature of the injury was simple and the offense was found non-cognizable, the police took no further step. On the following day, when the complaint was sitting, now this is pertinent, Millard, was sitting in the front of her residence, the appellant and the brother appeared at the scene. They were visibly enraged by the fact that Prembai had lodged an FIR. They started abusing. Now here is a case of abuse even. They started abusing her with repeated reference to her caste.
Now, if you can come to the opening paragraph.
I'm obliged.
Opening paragraph of that judgment.
A civil dispute of the ownership
1,
of the
2, 3,
possessory
4,
right of a
5,
piece of
6 lines.
I'm
For
sorry.
third line. Third line onwards.
Only
An ugly
put a
turn.
brick on the complainant, but also made filthy. I'm obliged. In fact, I wanted to read that, but this is the limitation of the virtual hearing. I am not attuned to or accustomed to virtual. Threw a brick and also made filthy and slurred remark of her caste.
So that led to that.
Even then, the division bench of the Supreme Court says that it is an abuse by using the SC/ST Act. Nothing but creating pressure, creating coercion on the accused. So these are the judgments which I thought I may place before you. There are a number of other judgments. I had selected only 4.
This will do. This satisfies my query.
Yes, who am I to satisfy that part? Your lordship knows I'm not on the penal code to segregated
No,
provisions.
we have distinguished that. We
Yes.
have told the learned council for the respondents also, we are not touching the penal code
Correct,
sections.
my lord. And
Only we are concerned with the SC/ST Act
yes, my lord.
offense. Now, if he can satisfy me after this, that yes, an offense is made up, it would be a different thing altogether.
Correct. my
Otherwise,
lord.
we are only on the SC/ST Act.
No, my lord. My respectful submissions are twofold. First is, it is crystal clear that SC/ST is not applicable. 31P is not at all attracted. First. Second, the other provisions under the penal code, my lord, to what extent it is attracted, your lordship have to peruse that also, my lord. What is the requirement of those two provisions of
418 and 418.
418 and 423? Now, 418, my lord, your lordship knows, says cheating is the offense, and 423 is fraudulent execution of a deed or transfer of containing a false statement or of consideration. Where and how these two offenses even are attracted in this case? When we had produced and there is a preliminary status report saying all the documents were placed, and kindly similar, not one FIR, there is second FIR also. Second FIR also,
It's on record.
Yes,
and
sir.
that is why
Yes, 77.
we had requested and pleaded and sought your indulgence to quest that as well, my lord.
That is also
First
on
is
record.
by the mother, by the daughter, and secondly by the father.
Father.
And the second FIR, my lord, your lordship will get on page
Very
77 to
challenge is
81.
only to one.
Yes, yes.
Only for one, my lord.
But that is the second one, because that was not registered, a preliminary inquiry was called for, Lord, the Lordship would kindly see.
Okay.
And this has been registered, if your Lordship sees page 77,
But
Lord.
you have not made a challenge to that second one yet.
Yeah.
Yes, the second one has been challenged, Lord,
Wait.
basically. My Lord should see.
This is that registered as Chokam PS case number 8 of 2021.
Yes,
That is the,
yes.
by the lady,
Yes, yes.
by the
20
daughter.
No, by
This is
by
by
the
the
father,
father.
by the father.
The subsequent FIR. The
Because
first
it's
FIR
the
not,
same
by the
content,
daughter has
Father.
not been challenged under this.
Under
provision.
this act.
Yes, right.
So it's the second one which is under.
Yes,
challenge.
yes.
At best, I may tell you, my lord, this case may fall, if at all there is an offense, under the Information Technology Act. Because what they are saying, and how IT Act is attracted, kindly oblige me by referring to page 76. Page 76 is their core concern, my lord. It is a mail which is supposed to have been sent, and according to them, it is a forced mail. Page 76, which is Annexure 14, my lord, dated 10th April 2021. They say this is a concocted mail, fake mail, and if at all it is there, then under the IT Act, my lord, section 66D is attracted.
But the FIR has not been registered under that.
But there is no FIR under the Information Technology Act, my lord, at all. So my submission, neither this FIR can be sustainable under 418, 423 Penal Code, or 31P, of course, is totally out. So on both the counts, whether so far as the allegation charges or what might be called the complaint against me, on both the count, your lordship's indulgence is sought under 482 to question. These are my respectful submission. And as I stated at the beginning, and I stand with my submission, that even in their complaint or FIR, 10 places they are talking only one word of English, business rivalry. And they are saying the control of the company, which is the sawmill in Arunachal, which was established as back as in 1979, admittedly, by the two accused. And because of, as I indicated already, I don't want to repeat, in the Corona period, since they were not able to travel to Arunachal, this kind of scenario had happened. These are my respectful submission. I am grateful.
Yes.
My lord, all these aspects as submitted by the learned senior counsel, my lord, I rely my case on this three-judge bench of
Niharika.
Supreme Court. Niharika Infrastructure Private Limited, State of Maharashtra.
No,
Yes, my lord. This has been 2021 judgment. Every aspect has been covered.
Please
beg
place
to-
it. Just place that judgment.
My lord.
Yeah, Niharika is in my compilation also.
Yes, it's there.
My lord, some relevant para.
Please do.
37.
Para 37.
Some relevant 37, 38, 50. It's a very comprehensive judgment, my lord. So
That reporting is from SSC.
SCC online. My lord, this is not, I have not found in the book.
Para 37.
My lord, there are multiple paras. We can
Please, please.
37,
No problem.
38, 50, 53, 54, 56, 57, 58, 60, 63, and last para is the conclusion. Para 80.
37 is the discussion of Bhajanlal.
My lord. And my lord, even in para 53, where they have referred to this case of SP CBI versus
Tapan
Tapan
Kaus.
Kumar. Yes, it is clearly mentioned. The true test is whether the information furnished. I'll take your lordship.
No, no. See, the argument of the learned senior counsel is, for the petition, is that it's not that there is no FIR, or it says whether that offense is disclosed from the FIR.
My lord.
And you also agree that as far as that SC Act is there,
It must have been wrongly inserted.
it was not done.
My lord.
There is no, other than page 48, second paragraph, there is nothing.
My lord.
So where is the ingredients with regard to the other two charges, other two sections?
My lord, that
Because it.
annexure 15,
the-
page 7,
the-
if we read
the
again. my lord.
Underlying factor for both the parties is the control of that.
Show me.
song. Hmm.
Cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect.
Hmm.
Whoever cheats with the knowledge that he is likely thereby to cause wrongful loss to a person whose interest in the transaction to which the cheating relates, he was bound either by law or by a legal contract to protect, shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or with both.
Okay, now, and the next one is for
23.
20.
Dishonest or fraudulent execution of deed of transfer containing false statement of consideration. Whoever dishonestly or fraudulently signs, executes or become a party to any deed or instrument which purpose to transfer or subject to any change any property or any interest therein, and which contains any false statements relating to the consideration for such transfer or charge, or relating to the person or persons for whose use or benefit it is really intended to operate, shall be punished with imprisonment for either description for a term which may extend to 2 years or with fine or
So these are the two sections which are now attracted here,
minor,
right?
as per the
Now-
investigative.
Now let's show me the,
Page number 77, annexure 15, the impugn FIR.
79, we can start off with that copy.
79. My lord, actually, this is also quite legible, my lord. Page 77, annexure 15.
70.
Second para.
Hmm.
Today at about 1410 hours, may I read, man? Annexure 77, the second para of the impugn FIR. Today at about 1410 hours, I was informed by my office that Anand Lahoti, along with his father Rajendra Lahoti, that is the petitioners, on 10/4/20 fraudulently and illegally sent an email from an email account, CM Namjoon so-and-so, without any concern or knowledge to the board of directors of Chokam So and Veneers Private Limited, which is a company which of my daughter and me are 58% majority shareholders. This email apparently held a resignation on my side from the company. Copies procured from the official website of the ministry that are paying for your kind reference. This,
Okay.
on the face itself,
No,
is what is the main contention. On the day when the respondent number 1 was supposed to call a meeting to appoint his daughter in the board of director, in the intervening period, someone sent an email that this informant informing about his resignation from the board of directors. So there is the shady area, my lord. How come a person having such high stakes now from their own admitted fact, the father and the daughter are having 90% of the shares of this.
father and the wife
Wife, the daughter is succeeded. Yeah.
So
So 90% having the stakes in this company, how
I got
can
it.
in suddenly,
I got what
and
you-
father is, my lord, the age factor, 76 years old. How is he even doing that email? There is also a matter of,
that's different thing. But this is an electronic mail which is being questioned now.
yes,
Now there is a provision under the IT Act.
my lord.
Where is that?
My lord, I will come to that part. My lord, in that sense, as let this matter be endorsed before the trial court, the charges can be charged.
No. We
There in the CC stage, consideration of charges stage, they can be discharged also if they,
not on that.
at this 482 petition, man.
When there is an allegation
My lord.
and there is no corresponding charge or section incorporated by the police, that means they were satisfied that that is not a fact.
ITA, my lord. My lord, that is a special act, my lord, but in the conventional act, this conspiracy and this cheating,
But how
it has
to-
been done.
What is the material to show that the police had examined this? They'll have to examine this in the manner prescribed therein.
My lord. There I
Right.
understand, my lord.
Huh? So if they have to exercise, they have not even touched this. This is up to 21.
That is what, my lord, but due to that order of no course, they are in the, even my lord,
And see,
I'll take their own,
preliminary report also. Preliminary report that was
that is for the earlier FIR.
That's for the daughter's FIR.
Yes, that time this resignation was not there. My lord, may kindly peruse, my lord, in that first FIR, this resignation part was not there. This is from the father, who is informing himself that somebody has sent an email informing my resignation. That daughter part is different one, my lord. That is not there. And even
No,
in the,
That means your email was hacked.
my lord,
Right?
that's clearly, yes,
Email was hacked.
my lord.
There is a provision for that. There is a procedure for that.
That is
Why
what, my
did-
lord,
why
for the
you did not-
investigator.
why- No. Why did you not pursue that? Because here, this aspect cannot be brought to light. Because hacking of a mail,
My lord,
email, it's a separate offense altogether. That will come under the IT Act.
my lord,
So when they have incorporated the SC/ST Act, Special Act,
my lord.
they could have very well done that also.
My lord knows that it's part of the investigating of the,
But then.
as
now
they were
have
laymen.
done it. What was your remedy?
There is their man. But only the investigator needs to let them file a proper report by the eye of the case before the trial court below.
No. We are considering this matter. Yes, madam.
Lordship, this is, the investigation did not been completed, Lordship, as per the records, Lordship.
But
Lordship,
see,
during
there was
Lordship,
a specific allegation which all started
Lordship-
from the para two.
yes, Lordship, this is,
There
Lordship,
is nothing to find that out.
this is understood, Lordship. That's why,
If
Lordship,
that is not there, the other things automatically falls.
that's why, Lordship, that the investigation can be completed, charge sheet may be filed, and can be altered in the trial also, Lordship. Can be added, Lordship, in the trial stage also, the Lordship, the sections can be added,
Even
Lordship.
if you proceed and file a charge sheet also,
Lordship.
I can consider this under 482. I
That's
can
why,
consider
Lordship,
quashing-
investigation has not
I
been
can
completed,
consider quashing under 482. There is no dispute. I have the powers.
Lordship.
So
It's always there,
No, my
Lordship.
lord, if
at
the charge-
best you can do one thing.
Lordship.
This report was of 21. Right?
26.
Much water has flown
2021.
now. Give us the updated thing, what you have found.
Lordship, we have not received the CD. Once we have received the CD and Lordship in the order dated, Lordship, this is Lordship 10/8/2022. Yeah, Lordship,
It is more than 3
additional
years.
PP submit that,
That's
he
it.
has already received the CD, Lordship, and the same is required to be sent back to the investigating officer as to enable him to continue the
See,
investigation.
No, that's it. Continue
Lordship.
the investigation. So we have not stopped him.
Lordship.
There is no question of arresting him, so that no coercive action will only come in when he is to be put under detention.
That's why, Lordship, he is, Lordship, freely, Lordship, he is moving, Lordship, and there's no investigation also not been state, Lordship. Lordship,
I'm
that's
not
why,
of that. I'm not of
Lordship.
When that no coercive action is there, that can be only to the extent of placing him under detention. Don't place him under detention. Other things you have not been stopped.
Lordship.
The police could have proceeded with the investigation.
Lordship.
Huh? What did they do for the last 3 years?
Lordship, that's why, Lordship,
One thing we are very satisfied. We are satisfied with that. And he also agrees.
Lordship.
The
That is there,
SCST
Lordship. Yes, Lordship.
Act, we are satisfied.
Lordship.
Now, the Learned Council has raised thing with regard to para 2. But we don't find a corresponding provision here. If that is not there, the police will not investigate on that lines. So that is gone. If the para 2 goes, the other things.
Then, Lordship, let me furnish the Lordship CD,
Give
Lordship.
it by tomorrow,
Lordship.
day after.
They have,
No,
it's
few-
part, Lordship, next week's Lordship, I need that next week then. If that Lordship, if this CD is not Lordship, not convincible that Lordship, then any order may be passed, Lordship. At least, Lordship, we'll have to see what kind of investigation going on at which stage, Lordship, to ascertain the
Okay.
state of investigation.
I'll furnish.
My lord, one more submission, madam. Paragraph 19 of the petition, madam. My lord, they have suppressed this annexure also. I have not found this in where they have said, they have submitted that in this another significant development proving that the daughter was behind the pregnant, that there was another email, but this is missing in this whole petition also, my lord, where they have said that there's this email, they have not annexed in their petition.
No. I think there is a mistake in the date.
Annexure 10, if you annexure 10, it starts from page number 57. Page number 57 is also not there.
Copy of the email dated 28/3/2021.
Rather, page number 57 is regarding some notice of court making. Page 56 is different.
Okay, Mr. Dubey, get that email.
They are suppressing material facts also. my lord.
Let's not jump into that conclusion. Sometimes it might be because Mr. Dubey is very busy. He missed out. If that is not the position, then we will catch hold of it.
However, my lord, prima facie, my lord, on the face of the record, there is an offense.
See.
SDST, I agree, my lord.
That's why I'm not wanting to close the matter today.
My lord.
Otherwise, SCST, I'm sure. Until and unless you can show me.
Now, she being the majority shareholder, there's every likelihood.
See, that majority shareholding thing is not yet been approved by the companies under the Companies Act. Has she been declared to be the majority shareholder after she has been?
No, I don't think. No.
I don't think so. You have.
If I can address to your lordship something, Lord, that so far as Lord appointment is concerned, as regard board of directors, Lord, there is no dispute as regard the shareholding. And Lord,
No, I'm saying that conversion from that majority shareholder to the board. That's what is being tried.
Lord, in
That
fact,
has not
I would
taken
say to the extent, Lord, that does not tilt the balance any.
I'm not on that.
My
The
lord.
whole thing happened.
My lord.
She wanted to be the director. And her allegation is that you are trying to block that.
Yes.
Right? Even to the extent of sending mail
My lord.
that the father is resigning. That's the allegation. So the issue is, but can it be done without a meeting being called by the board
Certainly
and a
not.
board taking a resolution? Because board has not yet.
Lord, the circulation also board meetings are being.
Okay, fine. Circulation also. But where is it done?
Lord, otherwise also, Lord, she as a board of director always, Lord, as a shareholder, always has a right, Lord. She has not invoked what is happening, Lord, as on fact. Lord, without, Lord, the company being active, Lord, on personal name and proprietorship name, Lord, the entire business has been conducted in the name of the company. That's why she is not interested. Otherwise, invoking the provision of Companies Act, my lord, she could have got the directorship. She could have changed us, my lord. There's
That's
so
what I'm
many
saying.
provisions
When
there.
the
my lord.
father and the daughter is having the majority.
Majority,
that
my
means
lord,
just-
we are nowhere, my lord. We could be thrown out.
My lord, but that is where the angle is, investigative part comes into play.
And what we have
Who
learned.
sent that email, my
No,
lord?
it's not investigative, but
Who
that
sent that
email is fine. But
Yeah.
what Mr. Dubey is saying, okay, fine. Let's set the better. Okay, when can you get it, madam?
First week of March, lordship, because next week there's holiday also, lordship.
Monday is a holiday. My lord, I'd like to inform also that I have also done the substitution part. In
Ah,
the
you have
both
done it.
cases.
You have
The
done it.
respondent, the
You-
father has already explained.
You have done it. You have done it. When? When will it be convenient to you in the first week or the second week of March?
I'm at your disposal.
No, please, we are here. There is no problem. You kindly give a date.
Fourth is okay. It can be on 7th, Millard.
7th, no issue. 7th.
7th is
Council?
Thursday, and we have old matters in Supreme Court, so we are comfortably placed.
Okay,
on
fine.
7th.
Heard the parties at length. List this matter again on 7/3/2024.
As part of-
It'll come to me.
Okay.
On the next day, fixed, learned additional public prosecutor shall produce before this court the updated case diary in connection with Chokham PS case number 8 of 2021, registered under section page 1 में आपको नीचे मिल जाएगा, मार दीजिएगा. Thank you, sir.
It's my pleasure and honor.
It's my pleasure. I could explore these aspects.
I'm grateful and obliged once again. Thank you very much.
The name?
ML Lahoti.
Obliged, lord.
ये फाइल हमको दे दो.
अपना क्या है?
मैं lordship.
They have filed an additional affidavit in support of their condemnation petition. So, Mother, when I will also see whether an affidavit is required to contact. There is a continuation of delay in preference resolution petition.
Okay.
There is a delay of 4,920.
That money suit.
Money suit was dismissed. It will be dismissal of.
Yes.
Lordship, on 14/12/2023.
You had filed the affidavit, additional affidavit today.
Yeah, yes, my lord.
Which date?
Today itself, sir.
So it's not on record, I suppose. Not on record. The learned counsel, you want some time? The learned counsel for the petitioner, Mr. So-and-so, submits that an additional affidavit has been filed on behalf of the applicant hearing today. आज का date दीजिएगा. Today, that is so-and-so. Registry to list this matter after 2 weeks.
20th of March.
20. Fine, no problem. Counsel, on 2/8/2024. Full stop. Registry to tag the additional affidavit filed by the petitioner along with the records of the case and list the matter again on the next day.
Representing only respondent number 6, 7 in.
Mr. V.K. Singh, learned standing counsel, Standing Counsel, Food Corporation of India, appears on behalf of all the
Only respondent number 6, 7 in.
or respondent number 6, 7, and 8. And madam,
I'm for respondent number 1, 2, 3, 4, and 5, Your Lordship.
and madam will appear for respondent number 1, 2, 3, 4, and 5.
Yes.
Number 18.
May I please, my lord? My lord, I am appearing for the private respondent and leading counsel, Mr. Tony Purton, is out of his station. As this matter was not a fixed matter, he could not appear today, my lord.
So Mr. Patin wants a fixed date to come before this court, right?
No, my lord, I think it has come up for the,
He is in India or he is gone out of India?
my lord, is it is native place, Rohit.
Okay, then it's okay. Normally we find that these days he is less in India.
Yes, my lord, frequently.
You are for the respondent.
Yes, my lord. This is only one private party. I don't even have the brief, my lord. I'm sorry, my lord.
No, they have they operating here. Okay, fine. None appears for the petition.
I believe.
Lordship, I am appealing for the petitioner, Lordship, through VC.
Okay. Heard the learned counsel for the petitioner, Mr. Bhachaji.
B. Mishra.
Huh?
BK
Your
Mishra.
name? BK
BK
Mishra.
Mishra.
BK Mishra. Heard Mr. BK Mishra, learned counsel for the petitioner, and also heard Mr.
HK Jammu, my lord.
XT Jammu, learned counsel appearing for the on behalf of Mr. T Party.
T Patel, my lord.
Learned counsel for the respondent. Full stop. On the prayer made on behalf of Mr. T Party, learned counsel for the respondent, list this matters again on. Give a fixed date for Mr. Party when it's convenient to you.
My lord, convenience of the petitioner
Yes,
counsel.
counsel, when it will be convenient to you?
Any date, Lordship, any date.
Second week, May, March?
My lord.
Or he'll have his financial net closing and all, he'll be busy. And communicate whatever I have told him to him.
My lord.
Let it be on 12th.
12 March.
12/3.
Yes, Lordship. Interim order may continue, Lordship.
Interim
There is-
order passed earlier to continue till the next date of this.
My lord, I have filed my Wakalam Nama in, I don't know, yesterday only, whether
In
it's
this
on the
case, for respondent number 2,
yes, private
Okay.
inform. Whether
Mr.
it's on the
T.
record or not.
So and so, Jacob appears for the, learned counsel appears for the respondent number 2. Full stop. Service in the matter accordingly stands completed. You are there?
I am appealing for, yes, Lordship.
Petitioner.
Yes, Lordship.
Yes,
Okay.
Bhattacharya.
Yes, but no, Mr. BK Mishra. Mr. BK Mishra appears for the learned counsel, appears for the petitioner. Full stop. List this matter again for admissions on when?
Well, at least after 4 weeks. I've not received the brief.
Outstation counsel is there, we give him a date. Whenever it's convenient.
Last week of March.
Lordship.
When it be convenient, 26, 27?
The date which was given in the last case, Lordship, that will be convenient for me, Lordship. I can be there.
14.
14th, Lordship.
You want some more
It
time?
was 12/3. It was 12/3, Lordship.
12/3. You want some more time in this matter?
12, yes, my lord, I have not received the
Oh,
brief.
we'll do one thing. We will post this matter along with the earlier matter on the week next. 18th or 19th?
My lord.
Can it be convenient to you, 18th or 19th? वो आगे वाला केस में ना उसको 19 कर दीजिए और ये भी 19 लगा दीजिए.
Highly obliged.
Lordship,
Thank you.
here I wanted to place in this case, since the service has been completed, Lordship, if
Admissions.
Lordship allows. Yes,
No,
if
we'll have
Lordship
it for
allows.
admissions. We'll have it for admissions and then you make your submissions. Because they have just appeared. He doesn't know also.
Lordship.
Highly obliged.
Obliged, Lordship, highly obliged.
So, and both for admissions. Huh?
My lord, in this case,
Hmm.
petitioners are claiming for payment solution in the matter of land acquisition.
Yes, where is your affidavits?
My lord,
नहीं फाइल करना.
no, my lord, we will file an affidavit, but my lord, against the division bench on that, the state government, they prepare SLP, my lord.
Okay.
The matter is pending before the Supreme Court, my lord. This matter is likely to be listed on 12 March, my lord. The Supreme
Will
Court. So we'll wait for
We'll
some
not
time.
refer about the Supreme Court thing. We'll only say that they'll file their
And the
affidavits.
letter message it is on 14th.
Huh?
14th.
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 No, 14 will be too early, my lord. If your lordship wants that, we should file affidavit, my lord. Give us some time. my lord. Reasonable.
If the matter is disposed of in the Supreme Court on 12th,
If not,
14th, that will be.
the another question, if not, then what will happen, my lord?
We'll have it a week later.
My lord,
We'll have it on 20th.
20.
You're comfortable with 20th?
No problem.
On the prayer made on behalf of the Mr. So-and-so Additional Advocate General, appearing for the respondents number 1, 2,
My lord,
and 3. 1, 2, and 3.
yes, my lord.
List this matter again on 23/2024, enabling the said respondents to bring their stand on record by way of filing an affidavit.
My lord, I'm sorry, my lord. Small correction, my lord. Two is represented by they have their standing counsel, my lord. I'll be representing only two, my lord.
You'll be only two.
Two, my lord, yes.
One and one.
One is
three.
Mr. Dumar, my lord, is a standing counsel land management.
Okay, and two, you
Two I'll be representing. The three perhaps by friend.
are second.
Yes.
Click the 1 by Mr. So-and-so, 2 by Additional Advocate General, 3 by Mr. R. Suikya. 4, nobody appears.
For Mr. Marto.
Mato is not
Marto
saying
is
today.
not present today.
Otherwise, my lord, I will not a necessary party, my lord. We are only executing agency, my lord.
For the timing we remain there.
It gives weight to the brief. Presence of the highway authorities give weight to the brief.
Deeply obliged.
Number 21.
Yes, counsel. What is this? Who is for respond number 4 here? Yes, tell me, how are you continuing? Just show me the order by which you are continuing after your superiors have asked you to leave that post. Maybe an illegal order. Maybe an illegal order.
So in fact, this matter,
Hmm.
I have received an instruction in the last occasion also.
Hmm.
In fact, this matter is become infectious also. It is as per the order passed by the respondent number 1 also. The post which the petitioner is claiming in this petition also. That post had been abolished also. Abolished by the department also. I think this communication letter he has not been received. So we need time to file our affidavit, lordship. I can bring this order on record, lordship. The petitioner in the instant case also, there is the training for midday meal coordinator also, midday also.
No, this is a different post altogether. This is district program coordinator.
Not so.
And but here this is MDM coordinator.
This is lordship.
Now, you make a statement that you are not functioning as MDM. Tell me, I'll record that, we'll dismiss the petition.
Also, this is the last order. With this order, lordship will see that I am not working as a MDM, lordship. I have been appointed as a Oh, your lordship, give us 1 week time, I'll just come.
Yes, what is the stand in the field? What is the position in the field?
My lord, I was appointed in March 2020.
I got it, sir. Today, what is the position?
They have not handed over the charge. I'm not functioning.
This will not go down well with the school.
In that view, to Madam Lordship, at least. give
We
us-
will direct for holding a department proceeding against you and place you under suspension for insubordination.
So in that case, Lordship, at least give us 1 week time.
No,
Because
you
again,
were having time, you were here from very long back. You were contesting this matter. Show me an order which has cancelled the thing given to him at page 23. I'll change my views, but otherwise, it's a case of insubordination, you have done a misconduct. We'll have it on Tuesday. Get categorical instructions whether you're holding the trust, and if you're, and you also get it. And if that be so, you will have to drop proceedings against it. This should not be permitted in service. This is not acceptable.
My lord, I had to inform you, my lord. My lord, this matter, it was earlier, matter was taken, looked after by colleagues Jamo, my lord. I have been engaged newly in this.
That's
case,
why I'm saying,
my lord.
today, make a phone call to the
My lord.
authorities,
My lord,
find out
my lord,
whether he is continuing as the MDM coordinator.
my lord,
And you find that that post is not there, midday meal scheme is being done by somebody else.
my lord,
Fine.
my lord.
We also understand what is the big reason behind this MDM schemes.
My
We
lord.
know that.
My
It's very lucrative. But we are concerned with the children,
My lord,
right?
my lord.
So, when? Wednesday?
Um,
Not more than, you can't go beyond first. Within first, tell me when you can come back. Only a phone call. I only want an written thing from your authorities. That this person, respondent number 4, is not continuing.
my lord, can you do 29, my lord?
This month,
My lord.
no issue. On the prayer of the parties, this matter again on 29 to 2024. The Learned Council for the respondents shall apprise this court on the next day as to whether the respondent number 4 is still continuing as the MDM coordinator. MDM coordinator under
PM portion scheme.
PM portion scheme under the Deputy Director of School Education, Dapuri Jog, Upper Subansiri District. Also, further orders as may be called for in the matter shall be passed basing on the instructions as received by the responding councils, council for the respondents. You can take this back. And if this is the position, clarify.
Lords.
And you also, so you also take an instruction, whether that post is gone, then what is the point in pursuing this matter? Yes,
I don't know, 22.
22, my lord. Here, my lord, I need time, my lord.
no, you're fine. You
My
get-
lord,
What, you need time
my
to
lord,
frame a
this-
policy?
I'm appearing for the first time, my lord,
Okay.
as a council matter.
Yes, council,
No,
one thing. We understand that the teachers are being brought in. Fine, no
Yes, sir.
problem. There is a policy to that effect. Where is that corresponding policy with regard to ministerial stuff of the government? We can't force the government to do that. That they will have to take.
My lord, to answer this question, senior counsel may be allowed to submit. Because
He's not there.
Not there.
Okay. Mr. Swenso, Learned Standing Council, Education submits that he be granted 4 weeks time?
My lord,
4 weeks time to file his counter in the matter. Full stop. You are paying for? 4 euros. Huh?
4.
That's one number 4. Deputy Commissioner. Mr. Swenso appears for the respondent number 4. आपका भी नाम ले लीजिए ऊपर में. So-and-so appears for the petition. List this matter again after 4 weeks on a date to be fixed by the registrar. And see, they have to have a policy decision. Otherwise, it will be difficult for this court to direct. We can only say, consider your representation. That is. And one thing, if you have taken a policy decision with regard to teachers,
my lord,
they are also working. That organization also cannot survive without them.
my lord,
Why? A similar policy decision, maybe in a lower, there it was 80%, 85%, maybe 20%.
my lord.
some input they are working for last 20 years with you.
Well, I have to discuss.
You please do so.
My lord.
And that is the affidavit we will want.
My
from
lord,
you.
my lord, my lord.
And if
My
you
lord.
find that, no, we cannot,
My lord.
then say that.
My lord, my name may be reflected actually. It's called list, my name is not there. Then item number 21.
Item number 21, Sarkana, learned council, appear in learned council, so and so, learned standing council. The name of the registry to reflect the name of Mr. So and so, learned standing council, education department in the cost list. In the cost list.
Deeply obliged.
Yes.
My lord, I need some time to file my affidavit, man. I haven't filed my affidavit, man.
This is by a village level kebab.
Yes, Lordship. I am challenging I have filed village level authority has been passed the order. That order was benefit for equally that order has been passed on merit basis. And thereafter, the private respondent didn't comply the village authorities order. Then I prepared the appeal. I prepared the education petition. Then my education petition has been rejected. I have
Your case is that I had not produced the order, fine, but it was a bounded duty on your part to call for the records.
Yes.
But now, very interestingly, they have filed an affidavit here and you have not filed a counter to that. Therein they say that the circle level kebab has got no legal standing.
That is different issue, Lordship. Since when
No,
I filed.
If that authority which has passed that order is of without jurisdiction, why would there be an execution under the act?
Lordship.
Now, this is something I don't know. I'm asking you for that.
Yes, Lordship. What in my education petition in which has been rejected, the order clearly says there is a ultra virus. Lordship, please kindly come to the
We'll
impugn
give
order.
you time, don't worry. Let me just understand that issue. Just to understand the issue, I'm asking you.
Yes. Impugn order. Lordship, page 22.
That is the English language. That let him use.
When there is any.
Let us not go into the literal meaning. It has been used to mean that is not maintainable.
Let the private respondent file.
No. You satisfy me.
Lordship,
If that
yes.
this is not by the village, but it's by that larger body, circle level kebab.
Yes.
Your order.
Yes.
No?
Yes.
If that is not maintainable, why should we entertain?
Lordship, the private respondent here.
I'm not on the issue. I'm on come to paragraph 6 of the affidavit filed by the government. And I think there is a judgment also of this court that this Gambura association is not the body prescribed under the act, right, ma'am?
Then Lordship, they could have been also filed against this impugn order. If
No,
it
why
is
should
really-
he'll not? Why should he do that? Because when his government contention is that is an order having no force of law, just a piece of paper. Why should he go and challenge it? Just this paragraph 6 satisfy me. If you're not today, on some other day. But this is the thing.
Please kindly list after 2 weeks.
Okay.
My lord, 4 weeks may be long.
4 weeks. Okay, done. After even this discussion, you want 4 weeks. Fine. On the prayer of the parties, list this matters again after 4 weeks on a date to be fixed by.
And let them
next
also
week.
file the affidavit.
The parties are at liberty to bring on record their respective stance by way of filing affidavits.
My lord, this at number 24, my lord. In this case also, I'm appearing for the first time, my lord. Even that the relevant case file has not been handed over to me, my lord, from previous.
Fine. We'll give you time. I think an affidavit would be called for, but
My lord.
My lord,
these are appointments of 2017.
my lord.
You were not even qualified.
My lord, at that point of time,
You made a vague statement that this may be backdated. Maybe backdated is different thing.
Yes,
But these are their orders before us, 2017.
I made a.
Now, when you are not qualified,
Mine.
you have not asked for a writ of quo warranto, have you?
I have,
Is there a writ of quo warranto here? Have you asked for a writ of quo warranto? No.
no, man.
Then why should we entertain a writ petition from a person who is not even qualified to apply for that post? Because you were pursuing your studies. You completed it in 2018.
2018. No, my lord, my only
And these are all contractual, barring one. The other seems to be temporary
two
contract.
of them are
One is a
regular.
regularization.
Yes.
Fine. Fine. That is regularized.
My
For
submission-
regularization, where is the scope for an advertisement? Because in the state, I think there is a policy.
No,
We'll
my
ask
lord,
him.
I am,
But tell me one thing, how can this writ petition be maintained?
my lord, my only submission before this honorable court with regards to back appointment, my lord, I have a reasonable belief, my lord,
How can you establish that? Their documents will not reflect that.
my lord.
File an FIR.
What I'm,
I think if these appointments are temporary appointments, maybe they are ad hoc.
my lord can see their appointment order, my lord, 2019 appointment order is also there.
Fine.
That was a regular appointment, my lord, pertaining to the
Page,
initial.
page.
May I take, my lord? to
That is that draftsman thing.
Draftsman, my lord.
Huh? That is,
Initial appointment was in the post of draftsman, my lord. That was redesignated to junior engineer.
no. 19.3, he
Yes.
was brought from contingency to draftsman grade 2.
Yes, my lord.
That post was subsequently upgraded.
Upgraded,
So
redesignated.
how can you have a grievance? He had a contingency service.
My lord, initial,
With that man gone, that man may not be able to be, because if they, I think they have a policy, I've seen in another case.
yes,
Contingency, they have an act also.
My lord.
So seniority basis, nobody, if somebody does not come and challenge other contingency worker, saying this man, no, it should be me, that is gone.
my lord.
But the others are fresh, but 2017.
Others are.
Whenever we'll dispose it of, whenever they do it on regular basis, you will also apply.
My lord, but there is apparent illegality, my lord. I can show it that.
I'll say that whatever has happened is all are temporary appointments, barring those two. Others, temporary, whenever they fill it up, you will also be considered. You also apply.
I can understand my lord is pointing out my locus, my lord. My lord, what I'm trying to say, even if the illegal.
Where is the writ of quo warranto?
That is there, my lord. But.
Anyway, file your affidavit.
My lord. My lord, 4 weeks time.
On the prayer of Mr. So-and-so, learned counsel for the education department, list this matters again after 4 weeks on a date to be fixed by the registrar. But if this matter comes back to me next time, you will have to satisfy me.
My lord, I will, with the judgments.
My lord, my name is reflected in the cost.
Okay, same. His name may be reflected in the cost.
Deeply obliged.
Obliged.
Cost list, sorry.
I don't know, 25.
Anybody appearing for respondent number 4?
No, my lord.
Yes.
You are appearing?
Yes.
Okay.
Here, my petitioner has not served any extra copies to us, my lord.
Hmm?
So here, my petitioner has not served any extra copies, my lord. Till that, my lord.
So by
We
today,
were ready to take up this matter. We were only waiting for respond number 4, but now you have not even served copies.
My lord, I have forgot to serve it. So today, within today, I'm going to serve.
The learned counsel for the petitioners shall serve requisite extra copies to the learned counsels appearing for the respondents within 2 working days from today. Full stop. List this matter. You will have to file an affidavit now.
Yes, my lord.
Madam ka naam, sabka naam le lijiyega. List this matters after 4 weeks on a date to fix by the registrar.
My lord, instead of 4 weeks, maybe 2 weeks.
Okay, they'll have to. You have not taken steps. I was ready to dispose of the matter in your favor.
All like man.
Only thing, constituency, they say X work is going on in Y. That's your case.
Yes, my lord.
Item number 26.
Your Lordship,
Your
Lordship, this is a joint application being filed by the complainant.
There is an order of this court requiring the presence of
Yes.
all the 3 here. They are here.
Yes, they are outside the court.
Call them. Why is the son not signing the agreement? And madam,
No, sir.
in this case, whether that same principle can be applied.
Lordship, here, Lordship, the accused is dead, sorry, victim is died, Lordship. The
304. right?
Lordship, it is already is there, Lordship.
Hmm?
It is already there, Lordship. 304 is already affected, Lordship. So, Lordship, whether 304 can be quashed, Lordship, that is the issue, Lordship.
That's my query.
Yeah,
Yes.
that's it, Lordship.
The squashing thing should not be taken very lightly because the allegation is you are driving the motorcycle in exceptionally high speed. You're a good driver, but unfortunately a man died.
Your Lordship,
Whether that is an act against that person or it's an act against the public.
Your Lordship, if you see the investigation report, police has said that accident occurred due to the poor visibility. Their intention was not to hit the man, but due to the poor visibility, accident occurred. For that, Your Honor.
Okay, that's the case, then you will be exonerated there. Fight it out in the trial court.
In this connection, Your Lordship, we made a settlement agreement and also paid the.
Why have you not signed it? Petition number 1, where the petitioner, the boy who was riding the scooter, his signature is not there. Why?
When the accident was occurred, he was admitted in the hospital.
The agreement was not made on that day?
No,
Or he continues to be in the hospital?
On 24 April, agreement was made.
And the accident is of?
On 22 April 2022.
And when was this proceedings filed? 24.
20.
Why? Why not immediately?
Actually, earlier we had filed this quashing petition, but this honorable, we had withdrawn the case because
Why?
we did not make the party to the complainant and the deceased wife. So this time we had made the party to them only.
Why were the parties called, madam? What was the discussion on that day?
Yes, the Lordship had pointed out that
Because the boy did not.
Yes, Lordship, that his signature was not there.
Hmm?
So his signature was not there, accused signature was not there. Although he is not minor, he is 21 years of age. So he can be signed on that agreement. So on the pretext
There
of
is
that,
no other doubt here.
Lordship, only the agreement, Lordship.
It does not
signature.
contain the
Yes,
sign.
Lordship.
Mother has signed.
Mothers. Because during that time he was admitted in the hospital, so he could not able to sign. Should I call all the parties?
Yes, madam. Should the parties be brought before this court now?
Lordship, the order
Because we
is-
have called them, what will
Yes,
they feel?
Lordship.
Just call them. Otherwise, they'll say orders are passed. We come, we are not given an audience. But can this 304 also, in such situation, then all the motor vehicle cases, you pay some money, come here, get your thing cost.
That is there.
What is the
Lordship.
sanctity then? Apprise me on this. I will fix the matter someday.
Lordship.
Hmm?
So that will bring the judgment also, Lordship.
You get me?
Lordship.
Because Power is there, no problem. but-
Settlement lordship, it is clear in the lordship, Lakshmi Narayan lordship, only there's a limited lordship is.
When there is a family thing,
In
this,
lordship,
that,
yes.
but in this sort of incidents,
Lordship.
or there is a neighbor, two neighbors having a fight between.
Yes, lordship.
But this could have been anybody.
Yes, my lordship.
This accident.
In 304A is lordship, is vastly lordship, they have applied lordship, because here lordship, there, maybe there, this fact is different lordship, but section 304 can be applicable in other section also lordship, then in the basis of that, they will come lordship before this court for the question.
Call him. Which is the boy?
He's-
Hmm.
Now he's pursuing BTech.
BTech.
Yes, at Guwahati.
And this is
This is the complainant.
complaining.
Yes. And that lady was a
Wife.
of the deceased.
आपका नाम क्या है? एक्सीडेंट आपने देखा था नहीं देखा था? नहीं। और आपका एम्प्लॉय का वाइफ कौन है? वो आपने साइन किया है इस सब में? हिंदी, असमिस, असमिस। ओ आउटगोइंग है खाली। कोई बात नहीं, कोई बात नहीं, कोई बात नहीं। आपने आपने इस एग्रीमेंट में क्यों साइन नहीं किया था? That boy who made that accident. नहीं,
ये नहीं।
आपने एग्रीमेंट में क्यों साइन नहीं किया था? क्या हुआ था आपको? कितना दिन के लिए? इतना भागाभागी क्यों हुआ था साइन करने के लिए एग्रीमेंट, सेटलमेंट करने के लिए? 2 दिन में ही? बेटा निकलने तक क्यों नहीं रुका? बेटा निकलने तक क्यों नहीं रुका? कोई कारण था? कारण जानना चाहता है कोई, इसमें ये नहीं है कोई, ऐसा नहीं माँ का कर्तव्य किया। कोई बात नहीं, ठीक है, हम लोग देखेंगे। थैंक यू। सेटिस्फाई मी ऑन दैट पॉइंट। 304 कैन बी कंडोन्ड ऑन। हम लोग सुनेंगे मैडम, आप लोग का जरूरत नहीं, कोर्ट बुलाया था उसको, आप लोग बुलाया, खाली सब ठीक है कि देखा है। अभी हम लोग केस का सुनाई करके जो होगा आपको जना देंगे। हम लोग देखेंगे मैडम, कोई चिंता मत करिए, लॉ में जो होगा वही मिलेगा, चिंता मत करिए। Satisfy me on that. That this power to quash can be done anywhere, everywhere. Tomorrow a murder. Let's say Mr. X murders B. B1 is the wife. Enters into an agreement with B1.
Yes.
Comes before this court, says, quash this proceedings. In some countries, you have this system of paying blood money. Pay that money, you are exonerated. But we don't have a system akin to that here. So how this court should proceed in such matters? It's not a question. It's a curiosity which I'm giving to you. I want an answer.
Your Lordship, accident has been occurred.
I'm not on
because
the
of
facts. I am on the question that it's not being a family, within the family. It's not a family dispute. It's not a boundary dispute. It's a death of a man.
Yes, sir.
And you have been charged, that means you are also negligent. It's because of your negligent and rash act this has happened. So you're this thing, today it's this person, Medhi. It
Yes.
could have been X, Y, Z, anybody.
Your Lordship, after the.
No, not you.
Yeah, yes.
Then tomorrow all accidents, wherever the people have money, it could be a situation that accident is done, come here, file an application under 482, get it quashed. Satisfy me on that. Get me judgments saying that in these circumstances also, this court has to interfere once there is an agreement.
This
498A and this, there is difference.
in this connection, Your Lordship, I could not able to furnish the citation.
You do that.
If you,
I'll give you time, no problem.
Yes.
I'll give you time. And madam also. In terms of the directions passed by this court while order dated 29/1/2024, the person's name therein had appeared before this court, and this court had an interaction with him wherein the parties agreed, parties to the deed submitted that they had actually executed the said deed on a compromise being reached by and between them. With regard to the accused not being a party to the said settlement deed, it was said that on the date the said deed was executed, the petitioner, the accused was in jail, was in hospital because he had also sustained injuries in course of the accident involved. Full stop. Heard the learned counsel for the parties. The learned counsel on the next day shall make their submission as to whether this court is required to exercise its powers under section 482 CRPC and quash the proceedings wherein a charge under 304A also is involved. List this matter again on, when do you want to?
20,
20,
28.
28th of this month,
29.
29, on 29/2/2020.
Much obliged.
I would like to.
You are for the applicant.
Lordship.
Who is for the petition?
Lordship.
You.
Lordship.
Satisfy one query. Forget that IA. You are not even concerned with this. You're not even concerned with this. Interim orders were passed saying that you are L1.
Lordship.
Demonstrate that. Page 23. That's the only case?
Yes.
Mr. Counsel, that's the only case? Page 23. Not 63. That is the, this is the
That's it.
page 23 annexure 4, right?
Page 20, yes.
3 of your writ petition.
That's it.
Now forget the L1, L2, L3 written in the top. That will not make you L1, L2, L3. The amount is to be looked into. Now you show me from the amounts that you are L1. Maybe I have read it wrong. You should show me.
That's it. As per the minutes of board proceeding and the comparative.
You forget the board proceeding. You show me from this that you had quoted rate less than the applicant. You are Takio Enterprises?
That's it.
What is your rate? 384, 17, 432?
That's it.
I was very bad in maths.
That's it.
Somehow scraped through. But I think 383, 94, 195 is less.
That's it. By.
Because you are not buying from the government, you are giving to the government. So the amount will always be the lowest. Right? So 383, 94, 195 is lower than 384, 17, 432. Am I right in saying so? Then how can you be considered to be L1? Because you see, here they have written as L1. Maybe the court did not at that point of time go into this. You read the above tabulation and comparative statement below. Tender amount quoted by so-and-so has been found to be third lowest. Right?
Yes. That's it.
Tender amount quoted by JGG Enterprises has been found to be the lowest bidder. I don't know why after lowest bidder it could be written as L3. If there is an explanation to that, please provide that.
That's it. As per the minutes of board proceeding, I was adjudged as the L1
How?
because
Was he disqualified? Was he disqualified?
he was not disqualified.
Then?
The tender law says that
Hmm.
the bidder who has quoted the lowest amount, he should be declared as
L1. So he has quoted the lowest amount?
The lordship in the board proceeding, they are the authority.
No. They can't go beyond that prescription. That shows the nexus. And that is why they have corrected that. If you come to the affidavit. If you come to affidavit page 47, they have corrected that.
Yes, that is my affidavit. That is my.
No, they have corrected it.
Lordship.
The first body amount is less, but I don't know why it put a L1 mark against you. It should have been against him. Subsequently, it holds that he is the lowest bidder. Still says he is L3. Now, if there is something to that, tell me. If there is nothing, the interim order will be vacated.
Lordship, regarding this affidavit filed by the respondent, I will file the.
No need. Forget your reply. Only tell me if that report, you know the facts. Tell me that page 23 and 24.
Regarding this correction, Lordship.
Not a correction. It is there. See, it's not a change in the number.
This document was.
You see, you have that page 47 with you.
Yes.
See the amount quoted by you. 384, 17, 432, right? It's written the L3.
Yes, Lordship.
381, 384, 17, 432, right?
Right.
No change. I'm looking from 23. And the respondent, 383, 94, L1C, 383, 94, 195. Right? What more is there? We'll vacate that order.
Lordship, I may be given time to file reply.
You file your replies, but we will not continue with that order. Because the last date is 31st. We'll keep the writ petition open. What do you say?
Subject to the outcome.
Subject to outcome, what would be there left? He would have taken everything away by that time. I'll give you one chance.
Lordship.
We'll have this matter.
After a week. After a week.
No,
On 27, Lordship.
27 may be tight up. It may not come.
28, Lordship.
28.
Lordship.
We'll have it on 28.
Lordship.
Huh?
My lord, first March, first March.
Lordship, 1 week time.
You have 30 days time still. You have made some supplies.
Lordship.
1st of March.
First of March.
On the prayer of the parties, list this matter again on 1/3/2024. Full stop. Madam, ऊपर में एक चीज लिखना. Heard the parties at length. Full stop. उसके बाद में, on the prayer made on behalf of the counsel for the petitioner, list this matter again on 1/3/2024 as a parted item.
Lordship. Lordship, one more matter, that IA 29, Lordship. IA 30, Lordship, that is also.
28, 29 will come together.
Lordship, one more IA is pending before this honorable court, Lordship. This is the connected matter with the same.
You mean to say other than 20, WPC 49 and 63, there is
Yes,
another
Lordship.
case?
Yes, Lordship.
Same situation?
Yes, same situation.
So what is the number?
IA 30 and in WPC 50, Lordship. 24.
List the above matters along with W50.
Lordship.
It's there in your petition. The order is there. 50 of 2023.
50 of 24.
24. On the date, man.
IA 30, IA number 30.
That will automatically come, I suppose.
Till then, Lordship,
The interim order will continue till the next date. So naturally, we have not vacated, so we'll have to. But Mr. Counsel, if there is any logic behind that, tell me. I don't think so.
Yes.
What do you say?
Yes,
Is there?
I agree with your lordship.
Item number 10.
Lordship, may I humbly pray that small observation may be made, and after if that matter somehow is not able to taken up on first, Lordship.
That I am here. I
Lordship.
have recorded everything.
Lordship.
Nowadays, everything is recorded here. Just rewind it. You get to know.
Briefly of life.
Item number 10. Yes. May I please, Lordship?
10.
Lordship, this is an anticipatory bail application.
Oh, time being. Okay.
Lordship, this is an application under section 438 of CRPC, praying for grant of interim
pre-arrest bail
Hmm.
against the applicant accused Gida Panio in connection with Doimuk PS case number 2/2012.
Have you appeared before the police?
Lordship, I have appeared. 19/2/2024.
Finally.
Yes. No, Lordship, prior to that also I appeared, but the police has failed to record my statement. Lordship, each time I go to police say come tomorrow, day after tomorrow.
Okay,
Then finally, Lordship,
it happened.
I had given an.
Yes, madam, get the updated status now, report, Siri.
Lordship, this matter is handling by the topic in Lordship, the additional PPT in it.
You tell him,
Lordship.
can you
He
inform
was
him?
here in the court.
Can you just get him?
Lordship, as per the.
You're protected by an interim direction.
Yes, 9/1/2024. I have complied all the terms and conditions.
But let's see, after your statement,
Lordship.
what is the effect? A status report from the IO, that's all. Then we will consider. Likhito. Heard Mr. So-and-so, learned counsel for the petitioner and also learned PP जो आएंगे, उनका नाम लिखिएगा. The learned counsel for the petitioner submits that in terms of the directions passed by this court, the petitioner has finally has appeared before the investigating officer on 19/2/2024 and his statement.
21 also.
19/2/2024 and also and on 21/2/2024 and his statements have been recorded in the matter. Also, they learned APP to furnish the updated CD in the matter along with the report of the IO after the recording the statement of the petition. Also, list this matters. We'll give you some time, 10 days time.
Lordship.
List this matters again on 11th को कर दिया 11/3/2024. Jenny, we have just, madam, we have asked you for, you're there, she's there. You're there. We have asked you to give, he has said he has recorded his statement.
Yes,
on 19 and 21.
Yes, Lord.
So you get an updated status, a report from the, also
We have.
updated after his report.
Yes, Lord.
What is that? Now, what are the observations of the IO after?
What has happened, Your Lordship? Though he has, I flag marked the statement, Your Lordship.
Gida Panyu is you. I think not a fit case for 438. You are not being disclosing things.
Whatever.
Whatever you have said here, that you have withheld. You said you asked so-and-so to make sanction orders. You gave the names. Somebody signed it. Then the authority wants to know who prepared it. You know who it is. Why don't you disclose the name?
Whatever.
No, you have not. The statement, it's not there.
I had disclosed everything before the IO.
No. Otherwise, why would he not record this? The names he has not recorded. That's what he wants.
Yes.
Prepared it.
Yes.
You said, asked one staff of office to prepare some sanction order. Who? Cannot be vague. Because you gave her everything and even an agreement of 5 lakhs per. So with this, what more is required? Anyway, this is subject to trial, but at least for us to now consider it. What to do, madam?
Yes, Your Lordship, if there is a clear objection with regard to, he's not cooperating in the
He's not
investigation. Also, Your Lordship will see that the FIR was filed by the Deputy Commissioner whose even signature was yes. He's not disclosing the entire fact because Your Lordship will see that 9 sanction orders were released, Your Lordship. Though this cannot be done by a person who is not sitting in the office. It will be going through the branches of the office, Your
Yes,
Lordship. He's
yes.
not disclosing any of it, Your Lordship.
If you protect them, we are going to ask you to, we'll dismiss this.
Lordship.
We will dismiss this. Mere giving a statement is not cooperation.
Lordship, I'm cooperating with.
No. What are you cooperating? You
Best
have-
of my knowledge, Lordship.
No. These are all within your knowledge. If you had not given this statement, I would not have asked you. You said, I don't know anything. Somebody gave it to me, I did it. Would have been different. Here you are very categorically saying, I visited DC office. This is his statement, I can disclose it.
Yes, Your Lordship.
I visited DC office, asked one staff of the office to prepare some sanction order. He sought me the names of the work. I gave him the name. 120, I got the signed sanction orders. Now, who prepared? That's what they're asking. If that person is brought on record or he is caught, other channels would come in.
Lordship, other persons involved in the case are also subject to the investigation.
Forget what others are
Yeah.
doing. But we want
Yeah.
you to disclose. That is
After-
cooperation.
After my disclosure,
You have not disclosed the name.
that is only limited knowledge, Lordship, I'm having.
No. You cannot be. Because this is something which you did at your instance to someone. Ask your client what he has said. And if that is so, we'll fix this matter again on 29th. Ask your client, we are not recording anything.
Lordship.
Ask your client before 20. Okay, we'll give it to you on 1st. Or why 1st? On 4th. Before that, he will go before the IO, make full disclosure.
Okay.
And the IO will communicate to her. On 4th, we don't get that. We are going to cancel the interim.
Your Lordship, if I may, Your Lordship. After the interim was granted, Your Lordship will see all the
Absolutely.
following orders. He has not,
Absolutely.
the last
See,
order
this
was,
court has been very soft towards you. And this is not the way you react. 2 times after last chance was given, this court was considerate enough to give you one more chance.
Lordship, I
And see, you were making a statement, now we will not believe it, that you had appeared, the IO was not there. But madam brought on record a letter from the IO, you never appeared. So now we believe that. We are not with you. This court was with you till the last order. And I was happy that you made your statement, but now, nothing. See, you don't know anything, that is one. Then no person in this world can force you. But here, these things that you have said, you know everything. But why the names are not being said? First, make full disclosure, madam, ask your IO. That within 1st he'll be there, within 31st, 29th he'll be there. And if he does whatever he says, get that updated here. And on the next date, if you don't do that, take it from me. If it comes before me,
Lordship.
rejected. List this matter again on the prayer of the counsel for the petitioner, who undertakes that he will take whatever further steps is required to be taken, who undertakes that the accused will take further steps as may be called for in the matter. List this matter again on 4/3/2024. Full stop. Ms. T. Ginny, learned advocate, learned additional PP, shall receive instructions from the IO before the next date as to whether the petitioner has taken any further steps in the matter.
Lordship, till then, agree order.
The interim order passed earlier. I can even require extended more, no problem. But you have to do your part on 1/3 till the next date of this. Next.
Deepu.
Yes, have you given the checks back?
Lordship, in this regard. Lordship, actually, the accused person and the complainant,
I require nothing. I just want the order of this court 5/2/2024, whether it has been complied with.
Lordship, I have filed complaints.
Forget the complaint. This order of this court, have you complied with or not?
Lordship, that check has been given in Manipur. Because
One check, 7 checks, 1 check utilized. Right? You have a case that this is the money, 25 lakhs, which I had given him.
Yes.
Fine, no problem. But there is an order of this court which requires you by this date to return the other 6, not to that person, to the IO. Have you done that?
Lordship, that I have written in the Manipur.
No. Where? To whom?
Manipur, Lordship, I have filed complaint.
In view of the director to hand over such checks to the IO of the case within period of 2 weeks. IO of this case. If you have not done it, make a statement that the petitioner, the accused has not done it. I will not extend the interim order. We are dismissing.
Lordship, that check has been deposited in Manipur because I have.
How can you show me, just show me.
Lordship, page number 26 of my bail application.
No. When did you deposit these checks?
Yes, Lordship, page number 26 of my bail application. Here, Lordship, this is a GDL page. That.
No, I'm not on that.
Lordship.
Just forget everything else. I want to the date when you deposited. When you deposited this check before the IO in any case. Okay.
Yes.
Tell me.
Lordship, page number 26.
This is the.
I have filed a complaint.
Fine. Here you have not given the checks.
Here.
On 16/1 you have not given the checks.
Yes.
When did you give the checks?
When last week when IO of Manipur called me for investigation. So I have deposited the check there.
Why did you do that?
They have.
You have violated the order of this court.
Also, they have.
You have violated the order of this court. And this court, violation of this court order, this, at least me, I will not be. Why? Why are you acting smart? Why is the accused acting smart here? There is an order. We are not extending. Sorry, we are dismissing on that count, violation of this order.
Lordship, during that time, Lordship, I am a resident of Manipur.
You may be, but when the order,
Lordship,
you are there, you are Mr. Tito Taba?
Yes.
Have you not informed the client about the order dated 5/2?
Lordship,
And the checks were handed over thereafter?
No, Lordship, during that time, checks were at Manipur. I am a resident of Manipur.
Fine. Fine.
So I have filed a case against the complainant and the same has been registered in Manipur. And the investigation of the case is also going on simultaneously.
That is the FIR at page 26?
Yes, Lord.
Okay, fine, let's see.
This is not the FIR, this is the GDL. And later on, it has been registered as a FIR.
The same thing?
Yes, Lord.
Okay,
May I please?
forget it. Now tell me, where is the reference of the 7 checks here? Numbers?
Also in my FIR. Also, the case is there. When
Whatever the case may be, now explain why did you violate this order? Have you gone to Supreme Court against this?
No.
Then just tell me why you have violated.
This case was subsequently registered at Manipur. I was summoned by the IO of the case to appear since I'm the complainant in the case. As such,
You were asked to appear. When were you asked to appear? Date. Give me the date.
that is on 18th of this month.
This month.
Yes.
You appeared before the IO. Have you shown him the order of this court? Give the name of the IO. We'll call him.
Also that we have.
We will call him. We'll call him. He'll appear personally.
We have.
Along with the accused. Both. This cannot be countenanced. Why did you do that?
Lordship, in that case, next time, Lordship, I will ask the IO. Because IO, during the course of investigation of Manipur case.
You,
the
IO does not know about this order.
Manipur IO doesn't know.
Then why did you not disclose? You are acting smart.
No, Lordship.
Yes,
That is
this order was there before you.
Yes, Lordship, that was.
We are not extending it. What do you say, madam?
Lordship,
Yes, Lordship, dear Lordship.
You are hindering with the process. This is contempt, direct contempt, criminal contempt.
Lordship, that during that time, the check was not with me. I'm a resident of Manipur. The check is in the Manipur.
Okay, we are not concerned. We are not concerned whether the check is in America, Manipur or Itanagar.
To obtain the copy of check physically, Lordship, I have to go to Manipur. And when I went to Manipur,
Why did you not show this order to the IO?
that was not done.
Then?
Lordship. Being a, Lordship, that was not done, but Lordship, the physical copy of the check was at Manipur.
You are playing smart, Mr. Here. We are not concerned. We are
Lordship,
not
that
interested.
case,
We are going to vacate this order.
Lordship, next date may be given.
No.
Lordship.
You have done enough. Your conduct.
And moreover,
not-
Lordship, regarding this case also, Lordship.
You may have a very good case. I'm not saying,
Yes, Lordship.
but the conduct of yours, not fine.
Lordship, this case, Lordship, actually, this is civil in nature. Of course, Lordship, when in compliance.
Get out of this. I'll understand everything. Get out of this.
Yes, Lordship. The check, the physical copy of the check was at Manipur. In the meantime, IO of the case called me telephonically.
Not very sanguine. This does not inspire confidence.
Lordship, that is the fact, Lordship.
No.
But Lordship, in that case, I'll show the order of this honorable court to obtain, to deposit the check to the IO. That will be done in the next day, Lordship. Till then, a date may be given.
No.
At least of 2 weeks.
No.
That is my humble prayer. And regarding Lordship, the terms and condition imposed in the interim bail condition, I have, Lordship, complied with all the terms and condition, Lordship.
But you have not done with the main.
Lordship, the check was not in my pocket during that time.
You did not disclose that to the court. The court gave you 7 days. You gave you time within 2 weeks from today. You never told the court that this is the situation. Huh?
Next time, Lordship. Yes,
No,
of
no, no.
course.
And this is the Manipur thing.
Yes. The case has been registered against the complainant also.
It's only registered on 1/2/2024.
Yes, Lordship.
Huh?
There is.
And it was reported on 1/2/2024. This order is of 5/2/2024. Right? We have our doubts now. 29/1/2024. Your name Hage Bate, so and so, okay.
There is complainant also.
What are these orders?
Lordship, that is for registration of a case.
Now, where is that document which will show that you have handed over the checks?
No, Lordship, that document is not there, but I have handed over to the IO of the case during the course of investigation. As Lordship,
That would be somewhere. He should have received it from you, seized it from you.
Lordship.
There, he has to seize it from you. Right? It's a material witness now. Has he seized it? Where is the seizure?
Lordship, thereafter again, IO of the present case has called me, then I have to come here again.
Not very convincing.
Lordship.
Yes, madam, what to do?
Lordship, here, Lordship, the updated city was called for Lordship. Here is reflected that this checks is still Lordship. They
Not
have
given-
not made us Lordship. They still with the accused person.
Next
And
step,
Lordship-
Lordship, I undertake that I will give the copy of the check.
Liz, this matter, seen the order dated 5/2/2024 passed by this court. There was the order dated 5/2/2024 passed by this court in the present proceedings. The petitioner was required by this court to submit the 7 blank checks kept by him pertaining to the informant. The petitioner was granted 2 weeks time for the same, hand over the same to the IO was given 2 weeks time to submit the said checks before the IO. Full stop. Mr. T. Tabak Learned, counsel for the petitioner submits that the said checks were handed over to the IO of a case registered by the petitioner in Manipur, Imphal, Manipur, against the informant hearing. Full stop. The petitioner's counsel undertakes that the orders passed by this court, the directions passed by this court, order dated 5/2/2024, shall be complied with by the accused, and the checks in question shall be handed over to the IO of 0 police case number 1/2024 within a period of 10 days from today. List this matter again on. इसको थोड़ा यहाँ पे लगा दीजिएगा. Today is 23. On 11/3/2024.
Lordship, may I have a small prayer?
Hmm.
Or Lordship, the season memo of the check.
No. We want the check. The order is checked. We want, go to Supreme Court, get it corrected. I'll not go beyond this. I can't touch this. I don't have a power of review. Criminal court does not have a power of review, mister.
Lordship.
If you don't do it, whatever consequences follow will follow. And the first consequence would be that we will not allow you to continue with this.
Updated CV may call.
The updated CD in the matter be called, brought on record. It will.
Like us.
We understand your apprehension, why you did it. But this court's order will have to be given price.
Till then, Lordship, interim may be continued.
The interim order passed earlier shall continue till the next date fixed. Full stop. However, the further continuation of the interim order shall depend on the conduct of the petitioner in assisting the investigation, as would be revealed from the updated CD, and the action required to be taken by the petitioner on the next day. Yes.
I don't know, Martin.
May I please, sir? And
Yes,
mandatory
madam.
bail application under section 438.
Huh?
The last date of listing, Your Honor, that was on 19th of February. The CD was called for.
CD has come, madam.
Lordship.
What is that? Tell me what is it?
Lordship, this FIR, his name is not reflected, but their statements, Lordship, his name is reflected,
Accomplice.
Lordship. Yes, Lordship.
She will take a plea that the accomplice statement by itself will not be enough in a case wherein narcotics active,
Lordship,
right?
Lordship, this is very heavy.
We'll have it at
Lordship.
2.
Application.
Today?
Yes, it is.
What is the urgency?
The bail itself.
We'll have it on the reopening, 27th. BA or AB?
BA.
BA, 27. 27. Yes, madam.
And if I may take this honorable court to page number 16 of the application, wherein the FIR is next.
Item on page number?
16.
Yes.
Hearing, Your Honor, it is seen that this FIR has been registered as Rupa PS case number 15 of 2023 under section 20C and 25 of the NDPS Act.
NDPS Act.
20C is with regard to contraband substance, that is ganja, and C is for the commercial quantity because 110 kg of ganja was recovered. If Your Honor may kindly come to page, the next page, that is at page number 17. The accused persons are numbered herein. First is Sanjay Basumatari.
This is Rupa PS case number?
15 of 2023.
Yes. Sanjay Basumatari,
Page 17.
Ines Musahari, Mitashara Boro.
Boro. The applicant herein is Sange Wangchu. So he has not been named in the FIR, Your Honor. First point. Second, if I may read the FIR itself, Your Honor.
This is an AB.
AB. I may read the FIR, the contents of the FIR. now. It is said that on 3/10/2023, I received an information from reliable source that one white colored vehicle, number AS01 BK 7373 XUV 500, is carrying some suspicious items, goods, so-called cannabis, which is being escorted by vehicle number AS01 DV 1112 Hyundai i10. And both the vehicles are plying towards Rupa. Instantly, I briefed QRT for further course of action and shared the information with CO Shergaon and other sister agencies. I installed 2 barriers near PHC Shergaon and started waiting for both vehicles. At about 9:25 hours, vehicle number AS01 BK 7373 500 was noticed approaching towards us, which was stopped to search. But the driver increased the speed of vehicle and broke both the barriers and managed to escape. Immediately, QRT along with me followed the vehicle number AS so-and-so and found parked on the roadside near Jigaon. In between, police also reached the incident site and vehicle was searched in front of CO Shergaon, ZPM Shergaon and locals. During searching inside the vehicle, approximately 110 kg suspected item, that is ganja, was recovered in white plastic bags. Subsequently, vehicle number AS01 DV 1112 Hyundai i10 was also found on the national highway near Jigaon, and 2 people caught from inside the vehicle. When they were interrogated, they have been found suspicious, and the details are as under. That is Dinesh Muhasari, Sanjay Basumatari, Mushahari, Sanjay Basumatari. These 2 are the accused persons who are named in the FIR. Now, Your Honor, my only submission before this honorable court is that first, that the accused person, the person hearing, the applicant hearing, has not been named in the FIR. And even the contents of the FIR shows that no disclosure with regard to the involvement of the applicant is here. No allegations has been made against the applicant hearing. And moreover, it also appears because the calls have been received from the police officers by the applicant, it is implied that somebody may have disclosed regarding his involvement. So hence, if in case of such disclosures, these disclosure statements are neither admissible under the Section 25 of Evidence Act, nor is it going to have any weightage later on in the trial, because as it is held in Tufan Singh versus State of Tamil Nadu by the Honorable, yes, Your Honor, by the Honorable Supreme Court.
Show me that. Where is that accomplished statement here?
Pardon, Your Honor. The case itself, at page number 2.
No, that is the head notes.
Yes, Your Honor. At particularly at paragraph.
Detailed judgment. Good.
Paragraph number 155, 156, 157 is the judgment that is given by Honorable Justice Nariman.
150?
155, 156, 157.
Majority judgment.
Majority judgment.
155, 156, okay.
At page number 141. Then. May I read one?
Okay. See, basic projection here is that these statements cannot be solely relied upon in the trial to convict that person who is not a named accused and from whose possession this has not been recovered.
Yes, ma'am.
But there are decisions of the Supreme Court which says that only because possession is not, from his possession contraband materials have not been recovered, that will not put him in clear. Our High Court has also held, Supreme Court has also held.
Yes,
so this judgment would come into effect when the matter is before the trial court. Now, for the purpose of his arrest or to consider or to have him interrogated to find out whether there is a conspiracy, there are more people involved in the link.
Yes.
Will this judgment help you?
Your Honor, because this particular case is only with regard to anticipatory bail, since we are only
Another-
concerned with
but-
anticipatory bail.
but
So,
We are now only on anticipatory bail.
yes, Your Honor.
So we'll have to see whether the absence of his name therein, accomplice is defined in the Evidence Act, section 130. Evidence Act, 113 or 133, let's check up. 33. An accomplice shall be competent witness against an accused person and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. Now, in a case wherein the Supreme Court has interpreted it in the light of NDPS, if there has to be something more, a corroborative evidence has to be there.
Yes.
In addition to this. Now, if that is there, we can only know from the case diary. Or after they interrogate you, they may leave you also. Yes, what is there, madam?
The case diary lordship, as per the case diary lordship, the last updated was done on 28/12/2023.
Whoa.
After that, no update was there.
Anyway, any reference to him?
Lordship, as per their statement, their lordship petition lordship, they have claimed that they have not been served under 41A lordship. But under 41A lordship is not required because less than yes lordship.
No, she has said that she has getting calls from the IO.
Lordship, because their name was revealed lordship.
It's there.
Lordship.
What is the nature? How is he implicated there?
Lordship.
Madam, find out a few more judgments.
No, no, I do have other
Okay.
judgments.
What is that?
So, the judgment passed by the Honorable Supreme Court itself, Vijay Singh versus State of Haryana, wherein
This is a statement of,
One the accused lordship who has been arrested.
but his name is not here.
Lordship is there lordship. Accused name is Sange Wangchu lordship. One Nima and one Sange, two names are there.
Sanjay here is Basumatari. He is Sange. I don't find Sange in the first page. That is what it should be. Sanjay. Oh, he's the middleman.
Lordship.
Now find out where you find this Sange Wangchuk.
Vijay Singh versus State of Haryana. Because in the case of Tufan Singh versus State of Tamil Nadu, the Honorable Supreme Court had already held that confessions recorded under Section 67 of NDPS Act would be inadmissible as evidence against the person. Therefore, in such circumstances, if in case the person was applying for anticipatory bail, the Honorable Supreme Court as well as the
Okay,
High
got
Court
it.
have granted anticipatory bail.
But was named by the co-accused and there was no other material available, right?
Yes, Your Honor.
Okay. Yes, ma'am.
Sorry,
Then-
I've wrongly placed.
No,
It's a
okay.
page 35
It's
lawsuit.
okay.
I'm so sorry. The disclosure lawsuit. Yeah.
And in addition to this, what do you have? What material is there in addition to this?
Lawsuit,
this
that's why
process?
lawsuit, the investigation was done till 20th December lawsuit. Now 2 months left, till that no update. Only status report is there lawsuit on the last page.
Hmm. SP, SIP. No headway made. No headway made. Because FSL report is not received and Sanjay Vangshu and Nima Dorji are not being able to be arrested. But you don't have any other material in his house. Nima Dorji, you got something.
Lawsuit.
But what about Sanjay Vangshu?
When they lawsuit, when they will reach their place, he already lawsuit left that place lawsuit. So
No,
they
no,
still absconding. lawsuit.
But any other thing other than the disclosure thing? Because
Due to out
everything-
of disclosure lawsuit, he need to be arrested as per this status report.
No, but something more, a little bit more.
Because this investigation lawsuit is till 20th December
Can
lawsuit.
you get the updated one? Next
This
week?
is, let's say that, they can do two lawsuit.
Your Honor, if I may, we are ready to cooperate with the investigation.
You will have
And
to, ma'am.
yes, Your Honor, because if in case this matter is fixed for another
Because see,
interim bail.
the projection made by there is not that you are a peddler. It's that you are the middleman. So your arrest may be important because you may give a lot of more sources. Because
For
you are
that
the
we
one
are-
who is the contact between the seller and the buyer.
No, so for that, Your Honor, we are ready to cooperate with the investigation. If Your Honor disposes of this case today itself by granting anticipatory bail to the applicant, then he will appear before the investigating authorities.
I was also looking into it, but
And if in case any incriminating evidence is found against him,
Then
the bail
very
can
difficult
always
to
be
trace you
cancelled
out.
later on.
it will be very difficult to trace you out.
No, Your Honor, we will comply with the directions of this honorable court.
What
And
is
the
his
sureties will
profession?
be there.
What does he do?
He's a semi-contractor
Based in,
based in Khalaptang, that
Where
is
is
in
that?
West Siang district. It's
Siang,
towards Tawang,
Arunachal.
Bomdila side.
As per section 31(1) lawsuit, 7(1) NDPS lawsuit, is restrict the ground of bail as well as the accepted bail lawsuit.
That will only come into the picture if contraband is recovered from our possession only. Presumption will not be effective at this point.
The disclosure there lawsuit, that's why lawsuit. And moreover lawsuit, why the investigation is still lawsuit 28(8) lawsuit, 28(12) lawsuit. After that, there no investigation was carried out.
I've also submitted a few judgments passed by the Honorable High Court of Punjab and Haryana as well as the Delhi High Court. All of these are anticipatory bail applications, where in similar situations where the accused persons, out there the accused persons were also named and disclosed by the disclosure statements of the co-accused persons. In similar matters, because the applicants were not arrested from the spot and no contraband items were recovered from their possession,
see,
they were given an
there is a
anticipatory bail.
decision of the Supreme Court.
Yes, Your
You can just note it down. 2021 10 SSC 100. Here this thing was gone into. Not been able to read it properly. There are 16 to 18. Then. Is 37 to last part. 37 Roman 2 last part.
Is the citation 2010 1 SCC 100?
100. Navaskar. Yeah, okay. Madam, when can you get the updated CV?
First week lawsuit. Before this, from Rupa. Yes, lawsuit. Otherwise, I'll try on next week lawsuit.
No, this matter was last listed on 19th of February. And it has been listed only after 3 days. So this is the updated CD.
Next week
It
lawsuit,
cannot
then
be
I'll try
updated
to.
anymore. Do not believe that.
Cannot be because they're waiting for you.
I'm
Your
ready to join
presence
you on.
to take them forward. Now, won't that be a ground? It's 100. 2021 10 SSC 100. Madam, I would like to have something, if there is some other material which will, in addition to the disclosure statement, if some other material is there where it shows. It seems that she is, the petitioner is an habitual middleman.
No, sir, that's
He
right.
is continuing. That's the only apprehension. Whether we release him on bail, he goes back to that. So just find out if there is something else, any other source information they have, that this man is also involved. He's a habitual in this line. Just get that. Otherwise, with that decision of the Supreme Court, we will have to consider her case.
Mr. Lordship, may this order, it will reflected that till.
I'll not reflect. It's not my, it's for you to show me.
No, sir.
And the 37 also requires you
No, sir.
to see to that I don't pass an order, right?
Because Lordship, till 28/12 only this investigation was carried. After that, there was no updated. They have not any Lordship. Here Lordship, they have empty Lordship. So that's why Lordship, I have it. Even updated city may be called. This will be same thing. This
Same thing.
there was Lordship. This one Lordship, in the order, it may be reflected that what happened after 28/12/2023.
दोनों का नाम लिखिएगा. Learned.
If I may please one, sorry. Your Honor, in that case, the interim may be considered for us today itself, because on the last date, it's also, Your Honor had said that we'll consider it today.
You appear,
Yes, Your Honor, we will.
right? You appear. Let her appear.
No, sir.
Take her, because nothing is not proceeding any further.
No, sir.
So, heard the learned counsel, Ms. So-and-so, also heard Ms. So-and-so additional L. Hagel, the additional public prosecutor for the state. Also, the learned counsel for the petition has submitted that the petition is in no way connected, is not a named accused, in no way connected. They submitted that the petitioner is not a named accused in the FIR in Rupa PS case number 15 of 2023, and it is his apprehension that he is being required to appear before the investigating officer basing on the disclosures that may have been made by the accomplice, by the arrested accused person. Full stop. Ms. So-and-so has produced before me the case diary pertaining to Rupa, the above noted case, and on perusal of the same, it is seen that one of the accused had named the petitioner as the middleman in the transaction that was involved. Full stop. However, it is seen that on account of non-receipt of the FSL report and the arrest of the petitioner and one another who was also named by the arrest by one of the arrested accused. So the investigation is not progressing any further. Full stop. In view of the said position, the petitioner herein is granted the privilege of pre-arrest bail in connection with Rupa PS case number so and so under section, madam ye aapko mil jayega, page 2, Rupa PS case number 15 of 23, page 2, blue line. So the petitioner on a bail of rupees, so हम लोग जो normal लिखता है 25,000 arrest in connection so and so one लिखे the petitioner, बाकी एक ही condition होगा सर, petitioner खाली एक number बदलेगा, petitioner to appear before the IO invariably IO without fail on or before 1/3/2024. Also, the IO and record her statement and record his statement in the matter. Also, thereafter, basing on the disclosure as made by the petitioner in the matter, in his statement, the IO shall carry forward further investigation and furnish the updated case diary before this court on the next date fixed. Conditions लिख दिया ना, उसके बाद ये अब मार दीजिए, मैं कर दूंगा. And list this matter again on 10 days, 15 days,
12 March.
12 months, on 12/3/2024 for further consideration. Full stop. The interim order passed today shall be further reviewed on the next date fixed.
Obliged to.
Item number 26.
Madam, the judgment house will not approve. You can take your that copies back. Then need to remember you don't show in corporate certificate. Yes.
May I please, my lord?
Where is the impute order?
My lord, it's a page number 47. 46 is the impute order, my lord.
The court produced the originals and then it came.
My lord, no.
This conclusion.
Again, it is fixed on 27th of this month.
Fine. Where is it fixed on 27?
My lord, this will be available only after tonight.
Your lordship, IA was rejected, your lordship.
No,
The main case is.
Main is statement. See,
No.
IA was age is not proved, right?
Yes, my lord.
So you relied on the school certificate.
So, my lord,
School certificate, right?
Yes.
You are not a matriculate.
no, my lord.
You are a school student.
Yes,
So that school records were called for.
yes,
The court perused it. It
yes.
was not satisfactory.
So, my lord,
That it says that there is an interpolation made there.
no.
Then
So,
how
my
can
lord-
this court come to your aid?
My lord, here, as per the infin order, only it is said that the handwriting and the signature of the headmaster is not telling. It is only
Fine.
ground,
No, see, this is a prima facie satisfaction.
my lord.
It has drawn a satisfaction based on that record. It did not go into an FSL and all to do that.
So-
It has drawn, you relied on a certificate, it examined, found that, no, that is a possible view. And if it is a possible view,
My
why
lord,
should we
it-
interfere?
The certificate of the alleged acquittal present petitioner was exhibited before the trial court. And on the basis of the certificate, it seems that the age of the accused at the time of alleged offense was 17 years, 25 months, 25 days. So, on that basis, one misapplication was filed before the trial court to determine the juvenility of this alleged accused person. So, for that headmaster was called. So, who entered the record at that moment of time, my lord, at the time of admission of class 1? So, from several times, the headmaster was summoned. Through Deputy Director School Education 0, who was earlier served there at 0. So, last date was fixed on 28/11/2023, where this headmaster was supposed to be appeared for examination.
What is the offense here?
It's a 366, 376, and read with section 4 of the FOXO, my lord.
We are not.
So, my lord, here my submission before this honorable court is that to determine the age of this
You have
eligible
already
person.
done. We'll not go in. We'll issue a notice.
Your lordship, your
At the
lordship,
best.
even for the notice, if I may just satisfy your lordship, they have sought for transfer certificate, your lordship, of the case. I have a judgment of the Supreme Court where it says that section 92 of 94 of the JJB is clear as to what document has to be submitted. I deeply apologize, your lordship. This is your lordship's copy. That's my marked copy. Paragraph 14, your lordship.
Paragraph 14.
Yes, your lordship. Page 5, your lordship. Even in this matter, your lordship, transfer certificate was produced, your lordship. We'll see the third last line, your lordship. It starts with, since it did not answer to the
So this is the second option, school
Yes.
from the school which has opted.
Yes, 94 of the JJB is clear that first it should be
Matriculation.
birth certificate from school or matriculation certificate, your lordship. If that is not there, the birth certificate given by a corporation, your lordship. If that is not there, the last option is of the ossification. Now, transfer certificate does not come under any of the documents provided in section 94, your lordship.
Where is that he has produced the transfer certificate here?
Your lordship will, they have annexed, your lordship.
Next, page 21, my lord. Annex 2.
When was this issued?
2012, your lordship.
2012.
And the incident is of?
2017 or 15. Now, while relying on this transfer certificate, why was the registered court? Your lordship will see they filed an RTI before the DDSC for production of these certificates, your lordship. And therefore, they have also annexed at page number 26, your lordship will see. This is the registration register, your lordship, which was originally produced before the trial court below. There was some discrepancies as per the observation of the trial court, and therefore, even after examination of evidences produced by them, your lordship, the court did not prima facie was satisfied, and therefore application was rejected, your lordship.
The application is this the one, page 20, page 29.
20, yes, 29, your lordship.
Yes, 29.
Did that original headmaster who had entered,
Yes.
did he appear?
He did not, he is supposed to be appeared. So no, otherwise passed to his appearance.
But the conclusion is here.
No, my lord. Here, as per the conclusion of this trial court, my lord, the report had to be submitted by the Deputy Director School Education 0. Address has been given to the Deputy Director School Education. The notice is to be served upon this headmaster, my lord. But that has not, the report is yet to be furnished before the trial court.
The evidence is over.
Evidence is over, my lord. So 27th of this month on final hearing is fixed, argument is fixed. So my submission is that, my lord.
Okay, madam.
Yes, sir.
One thing. Just come to page 43. Para 4.
Yes, Lord.
The DDSC of so-and-so is instructed to concern teacher posted so-and-so. Appear before this court for testifying signatures and entry made in the school admission register.
Yes, sir.
Now, if you come to the impugned order,
Yes, sir.
it seems that this is not done. This is a conclusion drawn by the court itself.
Yes, sir.
Hmm? So, the court itself wanted to do it in that manner. Now, if that man is alive, fine.
Yes, Lord.
But otherwise, how do you support this?
My only submission before your lordship is that, first of all, for claiming a juvenility when a trial is proceeding, your lordship, unlike JJB board under 7A, your lordship.
What you said is correct, that the transfer certificate is nothing.
Yes, your lordship.
But the register was before the court.
Yes, the register also is not part of any documents under
That
94.
register would be the basis for issuing that school certificate.
School certificate.
So the original came.
Yes, your lordship.
The base came.
Yes, your lordship.
And the court had it at page 43. 43.
Yes.
The court had the register,
Yes, your lordship.
right?
Yes, your lordship.
And it was disputed by the learned PP there.
Yes.
And thereafter, therefore, the court said calling. But here we don't find anything.
Page number 45 is the same order. Similar order, madam.
Here we don't find that the
Yes.
appearance of that person was there.
There, your lordship.
How do we get it?
Your lordship, my at this point of my time, my submission is only with regard to the register maintained.
Or we'll do one thing.
First, yes, your lordship.
We'll issue a notice here.
Yes, your lordship.
We'll say, we'll call for the scan copies.
Yes, your
And we'll say that the interim order will be considered on the next day.
Yes, your lordship.
That will do for you. Because with this thing, I'm not in a position to say this.
Well, only the deputy director school is 0.
No,
He is the person
that we will not.
No, my lord. He is the only person to furnish the address of this headmaster. Because he is the controlling authority.
Heard Mr. So-and-so, learned counsel for the petitioner, also heard Ms. MS T. Ginny, learned additional public prosecutor. Also, the present application under section 482 CRPC has been instituted, making a challenge to an order dated 28/12/2023, by which the juvenility of JUVEN ILITY, juvenility, of the petitioner was determined basing on the admission register produced before the court. Full stop. It is seen that the petitioner had submitted an application which was registered as I number 34/2023, praying for determination of his juvenility. Full stop. In terms thereof, the school records were full stop, and had relied upon a transfer certificate issued by the school authorities where he was initially admitted
in class 1.
in class 1. Full stop. The court, on perusal of the said certificate and in view of the objections taken thereto by the learned special public prosecutor, additional public prosecutor bracketed postcode, a requisition the original register for the session 2004-5 from the school authorities. Full stop. The court, while order dated 17/5/2023 on examining the incumbent in the post of headmaster of the school in question, had required the appearance of the headmaster of the such school during the session 2004-2005, and accordingly the DDSC of Lower Subansiri 0 was directed to instruct the concerned teacher who was posted in so and so to appear before the court for testifying signatures and entries made in the school admission register. Full stop. On perusal of the impugned order dated 28/11/2023, it is not discernible as to whether the teacher, as called for, while the order dated 17/5/2023 had appeared before the court on 28/11/2023. However, the court, on examining the original register produced before it, found that drew a conclusion that the name of the petitioner was incorporated therein afterwards by someone else as the signature of the headmaster, appearing in respect of the other students admitted on the same day, and appearing against the name of the petitioner did not tally. Full stop. The above aspect of the matter requires to be considered by this court. Accordingly, issue notice of consider accordingly. Accordingly, Niche, consider full stop. Next, Niche, issue notice upon the respondents. Ms. T. Ginny Lanet, additional PP, accepts notice on behalf of respondent number 2. Petitioner to take steps for service of notice upon respondent number 1 through the Nahaloon PS.
Yes, sir.
To the officer in charge, Nahaloon PS, by routing such notice through the registry of this court. Full stop. Steps within 2 working days. Full stop. A scanned copy of the proceedings in IA number 34/2023 in session case number 52/18 be requisitioned by the registry and tagged along with this court with the case records on the next date of listing. Full stop. In view of the issue that has been noted here and above, which requires consideration by this court, it is directed that we'll have to put it on a hold.
Yes.
It is directed that further proceedings in session case number 52 of the.
No, your lordship, your lordship is granting interim in stay in this. No, your lordship, if I may, your lordship, juvenility can at any point of time
Be raised, that's what
be raised because
you can say, it's there in the act also.
yes, yes.
What did I say? नहीं वो पूरा काट दीजिए. Full stop. Further orders as may be required in this case shall be so passed on receipt of the scanned copy of the case records, LCR, lower court records, trial court records, and on appearance of the respondents hearing. It is made clear. Should I say that it's not being stated?
Yes, your lordship.
It is made clear that this court has not in any manner restrained the trial court from proceeding with the issue, in as much as the question of juvenility can be considered at any stage of the proceedings.
Your lordship,
Unless you file an application, if you can take a time there, take it.
your lordship, in this case, though it's not reflected in the cause list, your lordship, my file also contains an IA for delay condemnation.
No, my lord, this is a criminal petition, so IA is not required. So my junior has prepared all these documents.
So if it's in the court record, it may also be taken a court record.
Same documents.
Okay, one more thing. This is an order of 2811.
Yes, your lordship.
What prevented you from coming?
My lord, this the eligible person.
No. वो last का line है ना ऊपर का थोड़ा हम change करेंगे. Only a notice will be issued. काट दीजिए तब पूरा. I did not see the date. Yes, you are too late. You just came a day before the thing.
My lord, eligible person.
And this is a unlisted motion.
Yes, my lord.
No. Issue heard also काटिए kindly. All full order. Issue heard Mr. So-and-so, learned counsel for the petitioner, and also Ms. T. Ginny, learned counsel for the learned additional PP. Also. Ms. Ginny submits that she would make her submissions in the matter as the copy was only served on her today, right?
Yes, your lordship.
Today. So it is to be noted that this matter was moved as an unlisted motion, and the impugned order and the order impugned herein was passed on 28/11/2023. So in that view of the matter, list this case again on 11/3/2024 for further consideration.
The petitioner is having only one kidney, so he was suffered in that account.
But the act that is being alleged against him does not support your statement.
Online money.
आगे वाला काट के मेरा इसको एक करो. I just lost sight of that fact.
Yes, sir.
28/11. Fine, no problem. If there is something, they will do for you. Don't worry. Kitna?
May I please, my lord?
Yes.
My lord, I'm appearing behalf of Mr. K. Saxena. He has been informed by the conducting PP yesterday only that today the PP has some personal difficulties.
Okay.
So both of them are absent.
On the prayer made on behalf of the learned counsels appearing in the party, in the case, list this matter again after 3 weeks, 2 weeks, after 2 weeks, 3 weeks, on a date to be fixed by the registrar.
Highly obliged.
What are the three?
None appears on call. For the ends of justice, list this matter again after 3 weeks, on a date to be fixed by the registrar. Yes, sir.
May I please? My lord, this is a 482 application filed for quashing of the FIR. in relation to Rupa PS case number 11 of the 21 under section 306.
Today
of the
we are
Indian Penal Code.
bombarded with Rupa police station cases.
No, sir.
We are having maximum Rupa PS cases today.
Seems so.
Yes, Mr. Hage, Ms. Hage, what do you say here?
Lordship, here, Lordship, actually, Lordship, was fairly submitting, Lordship, this case is ended handling by the additional PP Gigi Tado. On 2 occasions, I have take adjournment on behalf of him. And yesterday also, he left for 04 sub-urgency, Lordship. So I have not gone through all the records, Lordship, because
Lord,
PD is also.
My lord, if the
Yeah,
last
Lordship.
order is seen, it is taken on the same ground. Adjournments.
It will happen to you also.
My lord, I am not
We'll
interim, my
accommodate,
lord.
don't worry.
Interim player was.
You are from here or come from outside?
No, my lord, I have come from Guwahati.
Guwahati, okay.
And Lordship, moreover, Lordship, if this matter, Lordship, I have just gone to the case study, Lordship.
No, I've
This-
seen it, I've seen it.
Lordship, yes.
Don't open up. If you're not doing it, don't.
Lordship, yes,
I've
sir.
also gone through, don't worry. He has given some judgments also. Yes. Gone through. This time you give them your number. If they're not doing, they'll contact you. Kindly do that. Otherwise,
My lord, they could have told me in the morning itself, my lord.
that's it happens. That's why I said, I also understand. It's not very, it's only 3 months old, the site. So I understand. So you give you a number. If they have any problem, sometimes some problem happens. We'll have to be accommodative. But next time, please, madam,
No,
see
sir.
that he is informed.
No, sir.
Okay? And when do you want it?
My lord,
But this time, madam, we'll hear, finally.
Lordship.
No adjournment.
Lordship, if he is not available, then I'll
You
take.
will have-
Lordship.
I'll note that.
Lordship.
Yes.
My lord, 16 March.
On the prayer made on behalf of Mr. Tado,
Yes, Lordship.
Mr. G. Tado, learned additional prosecutor. List this matters again on 16/3/2024. सबका नाम ले लीजिएगा. 16/3/2024. It is provided that no further adjournment in the matter will be.
Saturday. Oh, sorry.
Oh, we are not coming.
Sorry.
Let it be 18th.
18, Lordship.
18 March.
Have, sir, it will be on
20. Any problem, Mr. Consul?
My lord.
Please look. Mr. Fukan, you be.
My lord, okay. 20 months. 20 months. 20?
I'll inform him. I'm sorry, apologize, Lordship, for
Young kid, he doesn't know. 2020. Okay, no further adjournment would be granted in the matter.
Big
Right?
apologize, Lordship.
Apologize.
I'm sorry for inconvenience, Lordship.
What?
Inconvenience.
No.
Lordship.
It's okay. Notes are ready. No problem. Anytime if I'm here, I'll do it. Don't worry.